Hun, hey. So come on. Hey, your dude Delgado tested negative. So I'm just gonna put him on normal, just everything normal. Just let him know that he could get called at any time for drug tests and everything. Had he tested positive, I would have like the other dude that we had together. But because he's negative, we'll just as normal. Okay. Oh, great. Yeah. Okay. For sure. Thanks, Rohan. Does Tristan Smith check in? Okay. Okay, here's a BVR. I just looked into that same person and it seems as though they were Who are you talking about? Who? Oh, you picked up a new case? Yeah, so we're looking into that to give you a BVR, but I don't, in where? I don't see on there, but I found it on J-Books. Hey, can you do me a favor? Can I give you a cause number? It's for Tristan. Did he pick up a new case?
It appears as though he might, Judge, because I just also spoke to his grandmother last, she called me this morning.
She called you, his grandmother called you. Is she the CW?
I called her before wanting an update and left a voice message and she gave me a call back. She told me that he came by the house with his friends. And he wouldn't leave, Tristan would not leave despite her requests, and then she called the police. And
oh no, he picked up a new case out of that.
And yes, Felicia just saw a new case out of that.
Here in Harris County, because I don't see it filed yet.
I think
it's just too new yet.
Like populated yet into the systems.
Okay, so I'm gonna put him on for tomorrow then, because okay. I mean he might be in custody now. I don't think it's on this posted, so. Yeah, so let's put him on for. I'll put him on for tomorrow so that we can deal with it, and then we'll tell Mr. Booker.
Okay. Do you still want a cause number, Judge? I can give that to you.
I have the cause number for this one, but I don't.
Yeah.
For the other one, I don't see it yet.
It hasn't populated on my end either.
Okay. You're certain though that there's a new case it's going to be filed?
So the grandmother told me that she has an offense report number, but she couldn't give it to me because she's at work right now and didn't have it on hand when she called me. But she had an offense report number. Felicia did just find a new case online, like on her system, on her end. It just hasn't shown up for me yet. So I'm not certain of anything. This is just
got it. Okay.
What I've been told. I do know that she called the police.
They took him.
I don't know if they took him. I don't know what happened.
Okay.
Yes.
Yes, that's the one. That's the attachment. I mean, Do you have such a person?
Oh,
okay, okay. Hey! Oh my God, sorry. We have a very good conversation. How are you? Hey, that's a different Tristan Smith. Well, not that. Okay, well. Judge, that was a different Tristan Smith. I'm having a judge.
It was a different Tristan Smith.
But.
Tell them to redact that or quit showing the video, one of the two. The individual called this morning and stated that that information will be shown as the latest this morning on one of the Memphis news stations on their video feed. So I'm gonna ask y'all to, anybody that's gotten that feed, to do whatever it takes to stop that. All right. All right. We ready? Everybody ready for the jury? Show the jury in. Would Vicky? Kevin. Hey, Kevin. Come talk to you. It's not related to this. My sister just texted me, said Andy's step died. Unexpected this man. Everybody good on the jury? You may, let's see, you may cross. You may cross. Thank you, Judge. All right.
Good morning, Sergeant Hodges. How you doing?
I'm good. About you, sir?
Doing just fine. Sergeant, a few things I just want to go over with you and make sure that I'm understanding exactly what your testimony was. You started off initially discussing the records that were received from Bandit Towing when they towed the car from Molly Bar Trails, correct?
Yes, sir.
And State's Exhibit 13, as been previously admitted into evidence, contained multiple photos of that car. And I just want to go back over a couple of those for just a second. Which way does the... You described Mr. Lee's vehicle as being distinctive, is that correct?
Yes, sir.
And in this photo, what are you describing as being distinctive about that vehicle?
I call it a racing stripe on the hood of the vehicle.
That gold stripe is running down the center line of the hood of that vehicle, correct?
Yes, sir.
Okay. We also looked at earlier back of this vehicle. I believe that you were looking at the tag. well, thank you, Justin. We'll get it going. What is distinctive about the backside of this vehicle that you described?
There's a vanity plate that says J. Lee, and then there's a sticker on the back that appears to say, "I love my Pomeranian."
And that sticker is a white sticker in the shape of a dog bone.
Yes, sir.
Were there any other distinctive features of the outside of Jay Lee's car that you were aware of?
If you look from the side, it might need to be a different side photo. That photo might not.
I'll show another photo, but is this what you're referring to by you want to look from the side?
Not that side. Or that photo doesn't show it.
This is the other side of the vehicle. This is the passenger side. What do you find distinctive on the passenger side?
The trim around the windows. The design of it.
I'm not sure what you're referring to. Judge, may I approach? Would you please tell me what you're referring to?
You see the design of the trim.
The insulation on the trim? Okay. Are those the only items that you find to be distinctive on the outside of the vehicle?
The rims.
Got a photograph I'd like to have marked as the next. Sergeant Hodge, I'd like to take a look at this photograph. And do you recognize that vehicle?
Yes, sir.
Whose vehicle is that?
That's Jay Lee's vehicle.
Is there a distinctive marking in that photograph?
Yes, sir.
Thank you. I'd ask that D21 be admitted.
No, Ms. Jackson, that'll be, D21.
And Judge, I request to publish. Sergeant Hodges, what is that on the side, on the driver's side door of this vehicle?
It appears to be a sticker.
And what does that sticker say?
J.
Gold colored sticker that says J.
Yes, sir.
Thank you. So as far as distinctive aspects of the car, we have gold stripe on the hood, a dog bone sticker, a vanity plate, and gold lettering of J on the side of the door. Is that correct?
Correct.
I think he said more than that. I know he said all those things, asked him a question.
I'll give you a chance to redirect anyway.
You also mentioned that you thought the window insulation was distinctive and the rims. Is that correct?
Yes, sir.
The window trim. All right. I would like to ask you about what was marked as States Exhibit 14, the video from Rainbow Cleaners. Timestamp on this video is 7:18:53. Got about 20 seconds to go. I'm just gonna play it. I would ask you to let me know when you see. I'm not gonna pause it. I want you to watch carefully. Let me know when you see Jay Lee's car enter the video. I'm just gonna keep it playing.
Are you playing it now?
It is playing now.
We still see the
I
photo.
apologize.
Take that picture there off of the screen before the play or not.
No, I just have to.
There we go, we got contact.
I got it. All right, we're still in front of the pertinent point. Please just let me know when you see Jay Lee's car enter the video. Watch carefully. It will continue to play.
Right there.
Based on your observation of that video, are you able to identify the gold stripe on the hood of that car?
From that video there, I don't believe so.
Based on your observation of that video, are you able to read the vanity plate on that car?
No, sir.
Based on your observation of that video, are you able to identify the dog bone sticker that says "I love Pomeranians"?
Are we able to replay it again?
Happy to.
Are we able to stop it when it is above the white mailbox at Rainbow Cleaners? A little bit further. Okay. Are you able to blow that up?
I'm not.
From right here, I cannot.
Based on your observation of this video, can you identify the gold script, the gold J sticker on the driver's side door of that vehicle?
I don't believe I could.
Based on your observation of this video, we're identifying a black car going down the road. Is that correct?
I believe the trim, the window trim that I talked about appeared similar.
Based on that clear image, which I believe is about as close as we can get on this video, based on that image, what can you describe about the window trim?
Can I get the photo?
No, I'm asking about that image.
Well, we had photos and stuff that we compared.
I understand that, but I'm asking you about that image.
All right, what was your question again?
I'm asking you, you said that you thought you could identify the distinctive window trimming. On that image of that video, what is distinctive that you can describe from that image?
Without being able to say that we compared it with another photo, I believe you've got me handcuffed here.
So is it fair to say that based on this video, based on stopping it, looking at individual images inside it, you can't identify any distinctive features of Jay Lee's car? Is that a fair statement?
Without having a photo to be able to show comparison.
All right, thank you. Sergeant Hodges, you also testified about some of your investigation at the Molly Bar Trails apartment. Specifically, you were asked about watching the surveillance video from the time. Excuse me one second. You were asked about the length of time on the surveillance video at Molly Bar Trails that you reviewed in relation to this investigation, correct?
Yes, sir.
And what was the time frame in which you reviewed those videos?
I'm not sure.
From what point at the earliest video the earliest piece of video that you reviewed to the latest period, what is that range?
Without being able to look at the videos themselves to go all the way back from the time that we got, I believe it was somewhere, I'm taking a guess here, I believe it was somewhere around 2 in the morning.
Roughly 2 a.m. on July 8th?
Yes, sir.
And up until the car was towed away by bandit towing?
Yes, sir.
And that was the only period of time that you reviewed with security camera footage from Molly Bar Trails?
Besides the footage that we got prior that was incorrect based on the times.
Okay, so fair enough. Aside from the footage you reviewed that you realized was incorrect, it resulted in you determining that it was in GMT time, converting that, those two, let's call them 2 sets of videos. Those are the only 2 sets you ever reviewed, correct?
Yes, sir.
You never reviewed footage from any other day prior to this?
I did not.
Okay, thank you. Now, on the Molly Bar Trails video, I believe that the timestamp for of what is on the camera. Now, I understand that it's adjusted for what the actual time is, but the timestamp for what was on the camera. Understand that it's adjusted for what the actual time is, but the timestamp for what was on the camera for when Jay Lee's vehicle enters Molly Bar Trails was roughly 2017. I'm gonna cue that up. And before I play that, you also said that the timestamp for roughly when an individual is seen running out of the apartment complex was 2026. Is that correct?
Yes, sir.
Are there any vehicles or other individuals that enter or leave Molly Bar Trails during that time period?
Your Honor, maybe approach this for 1 second. Come on.
Officer, again, during the time, and just remove the constant timestamps from it. During the time period from when the vehicle, the J. Lee vehicle enters Molly Bar Trails to the time that the individual on foot that we've been talking about is seen leaving, do any other vehicles or individuals enter or leave Molly Bar Trails?
I do not recall.
Okay. Well, Judge, I believe the video would speak for itself. It's only about a 9-minute strip. I'd ask you just play it.
It's your cross-examination, play what you want. Wake me up when it's over.
And Judge, I've got some, to prove my point, I've got some timestamps. It's okay, I'm going to skip ahead just a second. Within the frame of what we're discussing. Sergeant Hodges, do you see a white SUV leaving Molly Bar Trails?
Yes, sir.
What direction does that vehicle appear to be traveling?
Towards Rockets.
It made a right out of Molly Bar Trail, driving down Molly Bar Road towards Rockets. Is that
Yes,
correct?
sir. Yes, sir.
Sergeant Hodges, do you recognize that white car exiting Molly Bar Trails?
Yes, sir, I see it.
Is it likewise traveling consistent, making a right turn out of Molly Bar Trails towards Rockets?
Yes, sir.
Seconds. Do you see this blue car entering Molly Bar Trails?
Yes, sir.
Likewise, do you see the white or silver car entering Molly Bar Trails?
Yes, sir.
Finally, do you recognize this? Do you recognize that this gray car is exiting Molly Bar Trails?
I see that car, yes, sir.
What direction is it traveling?
It is traveling right towards Rockets.
Thank you. So, Sergeant, is it a fair summation to say that, and I'll represent that there are no more vehicles that enter or exit prior to the individual leaving on foot?
You say so.
Is it fair then to say that between that time period, 5 different vehicles are either entering or exiting Molly Bar Trails?
I didn't count them, but if you say so.
We had a white SUV go out, correct?
Yes, sir.
We had a white car go out, correct?
Yes, sir.
We had a blue car go in, correct?
Yes, sir.
We had a silver car go in.
Yes, sir.
We had a gray car go out. I count 5. Do you agree?
Yes, sir.
Thank you. And again, you've never reviewed any other video from Molly Bar Trails from any other day.
From any other day?
The Molly Bar Trails apartment, you testified that you've never, aside from these, we have 2 distinct now, I'll say, dumps because of the time difference. Did you ever review any other footage from the Molly Bar Trails apartments in relation to this case?
In relation to, there you go. That's what I needed to clarify. No,
To
sir.
this case?
Reference to this case, no, sir.
So based on that, you have no knowledge, aside from on this instance, on this day, about what cars, what vehicles may or may not be present in Molly Bar Trails?
Correct.
Okay. 1 second, Your Honor. Thank you. Tender witness.
Ready, Rick?
Good deal, thank you. I need to get 18 out. 14. I believe it's 14. Yes. Detective Hodges, are you familiar with the VLC program?
Yes, sir.
Are you able to, do you know how to zoom in using the software
I don't think you can zoom in on VLC.
on this?
Yes, sir.
Exit out right there. Exit? Nope. Minimize. There you go.
to
718.
718 on, can you pull it out of the thing like 718 on here? I need a second. I know how to do it, I just have to like go into like the settings. I just need a minute. So I said, can we ask for parts indulgence? And I said, is it display? Can you hear me? I was talking to you. Of course indulgence. Just for a second. Parts indulgence, like, and like, and is it playing on the thing now? I need to. Okay, go to video. I need to-
Everybody good on the jury? All right.
All right. While she's working on that, I'm gonna go over a few things with you.
Yeah.
Do you know what kind of car, I think you testified to, that you knew, the make and model of Jaylee's car?
Yes, sir.
What was that?
Ford Fusion.
You know the make and model? I mean, the year,
I believe it was a 2014.
2014 Ford Fusion?
Yes, sir.
You know the color?
Appears black to me.
And then it had distinctive markings.
Yes, sir.
And it looked like you described the trim around the driver's side window, the windows all the way around the car.
Yes, sir.
Was it chrome, kind of a chrome band?
It looks like it, yes, sir.
All right. And you also described the rims of the car.
Yes, sir.
Do you remember what that was?
The rims,
The rims?
they appear goldish colored to me. But you gotta remember, I'm partially colorblind.
Hand you exhibit 13. Does your color blindness affect your ability to distinguish between silver and gold? Can you tell?
Right there, they look silverish, yes, sir.
Metallic?
Yes, sir.
I got it zoomed in. Well, no, I can't see the time, but I got it like above the mailbox. I gotta pull back to my inside
You gotta go to the top.
because the box is in the corner.
Now, from all of the exhibits that we saw, Rainbow Cleaner, Rebel Drive, CD Web, Rockets, and the Molly Bar Trails, was it the same make and model of Jay Lee's car?
It appears to be.
Okay. Was it consistent with the chrome trim around the windows?
Yes, sir, it appears so.
Was it consistent with the same type of rims?
Yes, sir.
I think that's it. Just leave it right there.
Oh, I'm just gonna pull back so you can. There's the,
Nope, that's not it.
no, that's not it, but the truck with the trailer, I pulled back, so you'll have to wait a second. Where's that? I apologize. I went back too far, it's my bad. I need to look at. What was it, 718? There it was. There you go. Oh, move it this way a little bit.
Now, within that relevant time frame, from beginning with 718 at Rainbow Cleaners
Oh.
to Bolivar Trails at 725, did you see any other cars of similar make and model going in that same direction as?
That's how it's still across. I never asked to make a model car once.
The description of the cars clearly.
The issue of the identification that this car has been delved into greatly on cross-examination, and I'll let the state question in that area.
In each of those exhibits, Rainbow Cleaners, all the way through up to Molly Bar Trails, that you testified those cars were 2014 Ford Fusion. Identified it as Jay Lee's vehicle, correct?
Correct.
Did you see any other cars similar to a 2014 Ford Fusion of the same color and style within that relevant time frame?
I don't remember seeing any. No, sir.
Are we plugged in?
Yes.
Are we projecting exhibit 14? Your Honor, are we projecting exhibit 14?
You are, if 14 is Rainbow Cleaners, you are.
Can you see this?
Yes, sir.
All right, again, we're looking at that white mailbox that you used as a landmark to orient yourself on cross-examination.
Yes, sir.
You're going to see the white truck and the trailer, and then the Jay Lee's car. All right. Play that.
I'm playing it. It's just
Can you tell that we've zoomed in
Yes, sir.
We're at 7:18, it's just playing from the beginning of 7:18.
All right, we're at the
7:18, 20.
28:30 mark. We're going to 28:55.
Okay, I'm gonna let it play, I don't wanna, yeah, I don't wanna jump.
Are you gonna stop it?
Yeah,
Okay.
20:55, you want me to stop it?
When you see that back, the rear of the car.
There it is.
Okay.
I stopped it. That's, go ahead, that's the truck with the trailer. You want me to keep going?
Now let's do one more time.
You can kind of see this brake sticker right there. Sinister. This music play, look at the sticker.
All right, looking at the rear of that vehicle that passed in front of Rainbow Cleaners at the 28:53 mark, does it appear, I mean, tell me if you know or you know. Can you compare that image to the photo in Exhibit S13 and see if there's anything other than make model, other than the chrome around the windows, other than the wheels, that were distinctive?
Looks like the tail lights can be similar.
Anything else?
No, sure, I can't see it.
Let me ask you this. On that photo from the exhibit from Bandit Towing showing the rear of the vehicle, there's a sticker on the back.
Yes, sir.
And I don't know if you can or can't, but does it appear that you can see that in that image? Or is it too grainy?
Not for my eyes.
Okay. Now, you said earlier that you did blow it up before. Is that what you were referencing?
Back that way, I was referencing the window trim. When the vehicle first comes into the picture.
I guess my question is, when you were investigating, you said that you blew this image up
Yes, sir.
and observed the vehicle closely. Did you make any observations then about that vehicle? I did it again.
One of these videos, we were able to see what appeared to be the dog bone.
And the videos would speak for themselves on that.
Yes, sir.
Court's indulgence. Your Honor, if we could leave him, it's a question, but I'll further questions for him.
All right, Hodges, you can step down to the witness stand, but Harden reserved the right to recall you, so you can have no discussion or testimony with any other, with anyone, okay?
Yes, sir.
Is he free to leave the premises and y'all just call him if you need, or
That's when you go back to the office.
you can go back and be available if they call you back, okay?
Yes, sir. Thank you.
Thank you.
Can we approach her?
Sure, I'm getting used to
take a long time, I anticipate.
Long time. What's the parties? Where we stand on lunch anyway? Anybody know? Around noon, we got 20. We got anything we can do for 25 minutes? Tell some jokes or anything? Is that witness present? Uh,
I think he's coming over right now.
I'm gonna let y'all step back to jury room for just 1 minute, quickly let witness get here. We're gonna get started on the witness anyway.
Judge, the lunch just showed. The lunch just appeared in the
Lunch,
room.
never mind, lunch just showed up anyway. Court's gonna be in recess until 12:40. But the media stick around for just a second.
December 8th, 2023. Let's blame Olivia. It's Olivia's fault. Really? We're really going to go there? We're going to blame a 17-year-old girl for the actions and choices that man made December 8th, 2023. The choice to drink and drive to the extent that he was a less safe driver. And
police are searching for a gunman. City as police are searching for a gunman.
He ignores numerous other pedestrians, approaches the victim from behind, and shoots him in the back.
This is the moment that the first shot is fired into his back.
It seems to be someone who would have been lying in wait, so they could have been in just regular clothes. They might be an assassin. Who knows?
Obviously, it was intentional, it was premeditated, it was planned.
The manhunt continues this morning for an assassin who shot and killed a CEO on the streets of Manhattan. We've got new information about a possible message. And get this, it was engraved on the shell casings. Was this a paid professional hit? Our panel of New York investigators weighs in. Also, out of the Big Apple, what could be holding up the jury in the subway chokehold trial? That is what's trending today in true crime. And we're spotlighting the case of a Colorado dentist accused of poisoning his wife with protein shakes and then targeting a detective allegedly from behind bars. Those are the allegations. We'll dive into the story. Plus, our biggest week of sentencing continues as we're counting down to the Burn Powell murder case of Melody Ferris. It's all coming up next for you right here on Opening Statements. Good Thursday morning to you. Welcome to Opening Statements. I'm your host, Julie Grant. Are you ready for some coffee and some court? Let's get it going. Go ahead and grab that cup of coffee right now. It is time for my opening statement. Off to prison goes mean mama Melody. That's right. Melody Ferris will be learning her sentence today for murdering her husband, Gary, and for burning his body on their family fire pit. I started calling her Mean Mama Melody as soon as she started blaming her kids for her crimes. That's a mean mama, if you ask me. Now she's looking at being locked up for the rest of her life. That is Melody Ferris's reality. But my friends, that is not the reality that I want to focus on this morning. I want to focus on the victims in the case. Gary Ferris, his children, and his grandchildren. Life for them changed in the worst way when their beloved father and grandfather was taken away from them in such a cruel and heartless way. And for Gary's clients, they lost their attorney. He was a very well-respected legal advocate in the Atlanta legal community. And my heart goes out to all of the victims who loved Gary. Gary Ferris was a family man, and we saw this during the trial. We saw it playing out, how his death tore his children apart. And Mean Mama Melody caused them even more trauma by putting them through that public trial. So as this case comes to a close, may Gary Ferris rest in peace, and may he be remembered for all of the good that he did while he was on this earth. The good that he did for his family and the good that he did for his clients. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
Have you previously in any other criminal proceeding been referred for a competency determination?
Just say yes.
Yes, previously.
Oh, in Arizona, we've got Laurie Vallow back in court today. She's got what's called a Rule 11 hearing. This is a hearing all about her competency. Is she going to be competent to stand trial in Arizona? That hearing starts up at 10:30 a.m. and we will be there. Now, in Mississippi, we've got the missing student murder trial of Sheldon Herrington. That one continues this morning. You may have seen some of it yesterday. 10 a.m. Eastern is the time for it to resume. And we've got the convicted killer. I was just talking about Melody Ferris being sentenced today at 9 a.m. Eastern. We will take you into her Georgia courtroom live once it gets underway. Now, to our top story, though, this morning, as a manhunt is underway for a gunman who shot and killed United Healthcare CEO Brian Thompson. Now, this killing was done in broad daylight in Midtown Manhattan on Wednesday, and we have some brand new details this morning as police sources are saying that the assassin, get this, might have left messages on the bullets that were used in the shooting. The NYPD investigating the possible message, which appears to include the words deny, depose, and defend engraved on the cartridge casings. Let that sink in. Deny, depose, defend, engraved on those rounds that were fired at that CEO. Now, police say they recovered 3 live 9mm rounds and 3 spent cartridge casings. Alex Miller from Scripps News has the very latest on the search.
Julie, United Healthcare CEO Brian Thompson was gunned down early Wednesday morning as he appeared to head to an investors conference at the Hilton Hotel in Midtown Manhattan. Police are calling it a brazen, targeted attack. Late Wednesday afternoon, police released these photos of the suspect taken on security camera just before the shooting. Newly minted New York City Police Department Commissioner Jessica Tisch said the suspect arrived masked and on foot. He allowed other passerbys to continue on before Thompson arrived.
It appears the suspect was lying in wait for several minutes. And as the victim was walking to the conference hotel, the suspect approached from behind and fired several rounds, striking the victim at least once in the back and at least once in the right calf.
According to footage reviewed by the NYPD, the gun appears to jam, and then the shooter quickly fixes it and continues firing at Thompson. He then flees on foot into an alley, then via e-bike into Central Park, just 5 blocks away. Police told reporters they searched Thompson's hotel room and are interviewing coworkers and family members about potential enemies. His wife told NBC News that he had been the target of threats. The security video had no audio, so police were not able to discern if any words were exchanged during this attack. There was one witness present. The NYPD says they are interviewing that person in Midtown Manhattan. Alex Miller, Julie, back to you.
Our thanks to Alex Miller for that report this morning. Now, I have 2 very special guests I want to bring in. Both of them have patrolled the streets of New York City as part of their illustrious careers. Here with us, Mike Alcazar and Manuel Gomez. Manuel, let me begin with you, if I may, please. Have you ever, throughout the course of your career, seen messages etched into rounds?
Actuality, unfortunately, I have. I've seen that in Afghanistan.
I said to my colleagues, if anyone has seen it, it's probably you. Honest to goodness. Wow.
I saw it done to the Ambassador Cunningham in Afghanistan back in 2012. So this is not the first time. But again, the weapon proficiency of this guy was shown that, yes, he was proficient in using a gun, but no, he didn't take the proper steps to adjust the gun to deal with the suppression device that was on it. So when you put a silencer on a gun, that reduces the recoil of the sliding back to grab the next round. This is why what he had was a stovepipe, is when the bullet is up, sticking up out of the gun, and then he had to remove it by cycling back. Tells me that this guy is not a weapons expert, because he would have tested the ammunition before using a silencer. So it tells me that the gun was using subsonic rounds, which was very smart on his part, because that type of bullet has a lower sound ratio. So when you shoot the gun with the suppressor, it just goes like almost like a blow of air. And it shows me that this guy, even though proficient, wasn't a weapon expert, but clearly he is a trained killer.
This is really helpful insight from you. That's one of our biggest questions this morning. We keep talking about in our newsroom, was this a professional hit job? And so you would say a trained killer, but not a pro. Would that be a fair way to characterize it, Manuel?
Absolutely correct.
Okay, I appreciate it. Detective Alcazar, I want to ask you some questions. Let's start with a clip from the NYPD Chief of Detectives, Joseph Kenny, speaking to the public about this attack.
The motive for this murder currently is unknown, but based on the evidence we have so far, it does appear that the victim was specifically targeted. But at this point, we do not know why. This does not appear to be a random act of violence.
Okay, so pretty clear this was a targeted attack. The engravings on those casings, really stunning stuff. Detective Alcazar, I want to start with the idea that this happened early in the morning, 6:45 a.m., outside of the Hilton Hotel, a bustling area, lots of tourists, especially this time of year. Are you surprised that law enforcement doesn't have anybody in custody this morning?
Yeah, I mean, it's a dense society. This guy, like a fast bandit, hopped on an e-bike and he was gone in the wind. It's a daunting task. Our investigators are combing through all kinds of video surveillance right now, trying to track him. So, yeah, I'm a little bit surprised. I wouldn't be surprised, though, if they've already identified the suspect through the photographs and the Crime Stopper tips. So, again, I wouldn't be surprised if they're already on the hunt for him. They might have a suspect identified. They've not released that information yet. They're keeping their cards close to the vest, and they're releasing information that they want to the media to help with the case. So I'm confident they'll catch him very soon.
That's helpful insight as well, Manuel, that police, little reminder, are always several steps ahead of what they will let the general public know. And that's the way it should be. We've got to keep everybody safe. I want to show everyone what we know so far about the suspect, just a few details that officials have released. So they say that this guy was waiting for Brian Thompson, that it was very clear he was, as we say in criminal law, lying in wait to do this kill. We know that he's a light-skinned man, had a gray backpack on his back. You see it very clearly when he's raising the gun and aiming at Brian Thompson. And police say they're still investigating a motive. Manuel Gomez, tell me what you thought when you heard this news break, that this attack happened broad daylight on these busy streets.
Well, right, the fact that he was sitting waiting in the Starbucks and the coffee shop waiting for him at a certain time proves to me unequivocally that somebody at the CEO's job gave his itinerary to the shooter. Now, if I was a detective in this case, okay, I would be investigating the employees at the job and also their phone calls, because most of these companies record all the conversations. So the fact that you knew exactly what time he was going to be there, that itinerary would only be given by his assistant or by someone at the job that knew that that event was going to occur that day. So that tells me somebody in the company is providing this information to this killer, because he just didn't sit there randomly and, you know, say, well, you know what, let me take potluck. No, he was told exactly when, and that only came from that CEO's job.
Oh, that's good. This is really good, Manuel. Let's keep going. Detective Alcazar, who else are you looking to talk to get information about this?
Well, now that we found the etchings on the shell casings, I would comb through his correspondence, letters, email correspondence, anybody that was probably upset about a denial of claim. It seems like this guy has a vendetta. He wanted to leave these shell casings, so that's a big clue right there. So this didn't just happen, right? This guy, this individual sounds like he's upset, he's frustrated, so there could be a lot of electronic history mapping out what led to this. So I would definitely talk to coworkers. His wife mentioned somebody being upset about a denial of a claim, possibly disgruntled employees, like Manuel said. So there's a lot to go through. It's a puzzle pieces. We're all putting it together to hopefully identify this perpetrator.
Right, Detective. Thank you for that. United Healthcare Group issued a statement saying we're deeply saddened and shocked at the passing of our dear friend and colleague, Brian Thompson, the CEO of United Healthcare. We're working closely with the New York Police Department and asking for your patience and understanding during this difficult time. Our hearts go out to Brian's family and all who were close to him. The CEO for 3 years, he was 50 years old and had been with the company since 2004. Manuel, let me go back to you. I want to ask you about the gun used here. I'm curious, in a case like this, would you be thinking that the guy is going to try to ditch that weapon? What would the search be looking like if you're going after this guy who you know is in the wind this morning, but might he have left a weapon behind?
The perfect spot to go to. When he went to Central Park, first of all, taking an e-bike was the most smartest thing you could do in a situation like this, because you can navigate in and out the streets very quickly when a car cannot if he was being chased. Second, he chose to go into Central Park, which has numerous sewer locations where you could drop, dismantle that gun, throw it in a lake, throw it in one, drop it in one of the sewer holes. And this case also highlights one of the vulnerabilities that New York has, that it has not corrected since 9/11. and that is that we have a poor CTT camera system. We have a camera system in our streets that is outdated between 15 to 20 years. We do not have cameras showing the safety of the public with 4K or 5K technology. The only cameras we have doing that now are the speeding light cameras that catch you when you go to a 25-mile-an-hour zone going 50 miles and it catches your license plate. It's unfortunate that we don't have that technology that Israel uses, that London uses, that Spain uses. This case highlights the reason why we have to have that technology in New York.
This is awesome analysis from you both, as always. Detective Alcazar, take us home here. Go into professor mode, if you will. What are you thinking when you see that language etched on those cartridge casings? Deny, depose, and defend.
Yeah, big clue right there, right? I think he took it from a book. Somebody wrote that they might have taken this from an insurance book. So to me, as an investigator, I would look again. Anybody got denied claims, right? Anybody that's defending lawsuits, right? Perhaps the insurance company has a pending lawsuit. And then to depose, I would think it's his final action that he wanted to remove somebody from authority. So it speaks volumes. You know, I'm hoping that the public will help identify this guy, right? Because of his unique backpack that's like $300, his jacket that looks expensive. This guy's a gear guy. His suppressor on the weapon. So I don't think he bought this just for this assassination. This is something he wears every day, and hopefully somebody can help identify him. When they call Crime Stoppers, they'll see, you know, people motivated by money, reward. They're going to recognize his gear and call in a Crime Stopper tips if they haven't already. So that's all good information right there.
I could talk to you both all day. This is awesome analysis. Thank you both so much. And fortunately for us, you're staying with us for another segment. Mike Alcazar, Manuel Gomez, thank you much. Coming up next for you here on Opening Statements. Jurors are weighing the key pieces of evidence in the subway chokehold case. The jury's still out as we say what could be the holdup, and will they ever arrive at a verdict? Plus, we're shining a spotlight on a Colorado dentist accused of poisoning his wife. But he doesn't stop there. Now he's accused of plotting to kill a detective on his case. We'll deep dive together when we return.
Tonight on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments. We have a big hour ahead here.
Your deplorable actions are unforgivable.
The community still doesn't know how this Boston police officer died.
He can't prove one element of his case. It was a dramatic day, a dramatic moment inside the courtroom.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
Now for what's trending in true crime, jurors in the subway chokehold case are resuming deliberations this morning after still not being able to arrive at a verdict. Daniel Penny is accused of killing 30-year-old Jordan Neely after putting him in a chokehold on a crowded New York subway. Neely, at the time, was suffering from schizophrenia and was high on drugs and was shouting death threats at passengers, and that is when Penny intervened. Now, on Wednesday, the jury asked to see 3 different pieces of evidence again. They wanted to see the Vasquez video, it's called, which shows what happened on the train that day, the full video they wanted to see. They also wanted to see a compilation of police body camera videos, as well as video of Daniel Penny's NYPD interrogation. What do you think about those pieces of evidence that they wanted to revisit? What might they be stuck on? Here to discuss, let's bring in our power panel. Retired NYPD detective and Professor Mike Alcazar, criminal defense attorney and civil attorney John Phillips, and attorney and former homicide prosecutor Randolph Rice. It's great to see you all this morning. Ooh, let's read the tea leaves a bit. Randolph Rice, would you start us off, please? What are you thinking?
I love if I'm Daniel Penny's defense team. I think this is a great sign that they're asking these questions. They're looking at more evidence, or they're looking at the evidence again to determine if he was justified in his actions. And I think they've also got questions about, did he actually cause the death? Remember, that was one of the big issues that was raised, was the actions of Daniel Penny the cause of the death, or were there other factors like the substances that were in his system at the time?
Right, great points. John Phillips, let me go to you next. Where's your attorney mind going as you hear these questions from the jury to see those pieces of evidence again?
A lot of things. So there's certainly the comorbidities, the whether the drugs had an effect on the death, and I think the doctor said that even if there was like a reference to an elephant, had enough to put down an elephant, that they wouldn't have caused his death, that it was the chokehold. I think that was an overstatement, but we're dealing with the issue of kind of the polarization of jurors in this society, where some are kind of the reptile that want to protect, themselves and fear this kind of attack, and then others address homelessness and houselessness and the mentally ill, and want to, maybe not use so much force as you can. So it's a conflict.
Right. You're all making great points. Detective Mike Alcazar, last but certainly not least here, what are you thinking, please?
Well, as a New Yorker, I put myself in that situation. I'm sure many of the jurors do also, because they've ridden the subways, they've seen homeless people, they've seen the mentally ill doing crazy things on the subway. So maybe they're reviewing all the information to see, as your previous guest said, that maybe there is some kind of justification. Maybe he took action because maybe there was the lack of police presence, which is a failure on the New York City administration. So these are the things that came up in my head as a New Yorker.
Right, and appreciate that context, Detective. It's scary on the New York subways, isn't it? It can be really, really scary stuff, and so that context is key. And fortunately, this jury, I'm sure, will be very familiar with the subways and the encounters that can happen on a daily basis in a big city like that. Let's turn to another aspect of this case. We know that Jordan Neely's family has also just filed a civil lawsuit against Daniel Penny, accusing him of negligent contact, assault and battery, causing injuries that ultimately led to his death. Let's take a listen to how Daniel Penny recalls the incident.
We were all scared. Mr. Neely was yelling in these passengers' faces, and they looked terrified. The reason why there was no video at the start of the altercation was because people were too afraid getting away from him. I knew I had to act, and I acted in a way that would protect the other passengers, protect myself, and protect Mr. Neely. I used this hold to restrain him.
So we're asking this next question. Even if Penny is acquitted, I'm just saying this just for the sake of our analysis today, let's just say this is an acquittal. Is this criminal trial perhaps just the first hurdle for Daniel Penny in the world of his legal problems? John Phillips, let me start with you on this, please.
Julie, I do this every week. So I think three out of the last 5 weeks, I've been in the criminal trial where I was filing a civil lawsuit. And, justice is spelled one way, but it's defined by criminal justice and civil justice, and sometimes the court of public opinion and legal change. And so I do suspect that there will be, more of this story to be told under an entirely different standard, because they would just have to prove the preponderance, just a tiny little bit more of the evidence that there was a wrongful death or assault or what the core issue is.
This is really helpful, John. This is a teachable moment, really, for everyone who wonders about this type of thing where two different legal actions can result from the same incident, and the disposition of the criminal case often dictates what happens next in the civil case. Randolph Rice, would you take it from here? Let's say the opposite happens. Let's say it's a conviction for Daniel Penny. What might the civil situation look like then?
Yeah, I think the civil situation really takes a back seat to this. But I got to tell you, if I was the family of the victim here, I would have held off. I don't typically like to advise clients to file civil suits while criminal proceedings are going on. I think that can often taint the situation. Now, you know, the jurors are not supposed to take into consideration factors outside of what evidence they've been presented. But let's say they get a whiff of that their family is seeking some sort of monetary, may sway them to say, wait a second, is this just a money grab? And is the prosecutor sort of in the same boat as that we're sort of overreaching here? So I don't like when they do that. Look, he gets criminal conviction. At the end of the day, what's a civil judgment against him, a money judgment against him really going to matter?
Appreciate it, Randolph. Mike Alcazar, final quick thoughts on this case in New York City. Does it have everybody talking? Is this one that people have really just seem to be taking opposing positions, and there's a lot of polarization with it?
Oh, yeah, this case is definitely polarizing. All my friends and New Yorkers are talking about this daily because it's something that we experience, you know, going to work, riding the subway. So it's an issue of like safety and protecting ourselves and police presence. So that's why I think the jury is kind of like taking their time trying to figure this out, because they want what's best for the case. They want what's best for the family. They want what's best for the defendant and what's best for New York. So it's definitely a very challenging case to decide.
Right. I love how you said that, what's best for New York, because really this is going to set the tone for what happens going forward. People could be afraid to intervene for fear of a criminal case or a civil lawsuit coming at them. We've got to leave it there for now, but great discussion with you all. We've got to say goodbye, and thank you to Detective Mike Alcazar for everything this morning. Thank you for your time and expertise. Still to come here on Opening Statements, we've got a Colorado dentist accused of murdering his wife by poisoning her protein shakes. And guess what? This guy is back in the spotlight for allegedly plotting another murder. We'll explain. And our biggest week of sentencing continues this morning. All female defendants, too. Just about 30 minutes from now, convicted killer Melody Ferris will be back in court to learn her fate.
Approach to dentistry begins with sincerely listening to the patient and wanting to find out more about where they're coming from and what they're looking for and what they want. The most satisfying thing about my job is when a patient leaves and they say, easy.
By poisoning her protein shakes. The father of 6 has pleaded not guilty to killing his wife of 2 decades. Prosecutors claim the dentist searched online for ways to poison his wife in a way that would appear to be accidental. Angela Craig died back in March of 2023 of poisoning from a substance that's found in over-the-counter eye drops. This is according to the medical examiner who performed her autopsy. Now, there are also allegations of multiple affairs for the dentist as well. Scripps News Denver has more on the case.
In court documents, prosecutors say the most damning evidence against the Aurora dentist accused of poisoning his wife's protein shakes comes from one of his mistresses. James Craig faces a first-degree murder charge and charges of tampering with physical evidence related to the death of his wife, Angela, in March of 2023. Prosecutors claim evidence from a mistress show Craig wanted to kill his wife long before her death. For instance, voice messages allegedly between Craig and the mistress say things like, "Do you know anyone who can help me with my problem down here? I can pay handsomely. I want to be with you." And hitting up a homeless person actually sounds like the only choice right now. Craig's defense attorneys argue this evidence should not be admitted at trial, saying it would violate their client's due process rights and that the witness was coerced into making statements against their clients. More than that, the defense wants all of the charges against Craig dropped, saying there's been outrageous government conduct in the case. Prosecutors say the witness spoke with investigators voluntarily and are requesting the judge deny the defense's motion without a hearing.
Oh my, there's so much more to discuss here. I've got 2 great guests to help me do that. Still with me, attorney John Phillips and private investigator and retired Army intelligence officer Manuel Gomez. Whew. All right. When I first heard about this, I kept thinking, oh, we've seen an eye drops murder case before. We saw a trial playing out here on court TV. So let's start first with the allegations of the murder and the way in which it was done. Manuel Gomez, let me start with you. As an investigator, talk to us a little bit about what goes into cracking a case such as this one, where you got the smiling dentist and nothing appears on the surface to be wrong.
Well, you know, one of the things I want to highlight in the beginning is that there's a failure of the hospital. This lady went numerous times. And yeah, granted, potassium cyanide is the chemical that can barely be detected. But arsenic is one that does get detected, and even in small doses. And the fact that she went over several times to the hospital and no one detected this, I mean, it's just a travesty of the medical practice that this woman died because they failed to identify this chemical. And it's sad in this case because this has happened in numerous cases throughout the past 10 years. I've seen at least 20 of them, and that, you know, people are going, trying to get help, and, you know, doctors like this take advantage of their skills.
This is really great insight, Manuel. And let's take it a step further. John Phillips, let me tap into your legal expertise. Could there be grounds for a civil lawsuit against the hospital, perhaps?
You know, I hadn't thought of that, and I agree. You know, medical malpractice and kind of what the standard of care is, you know, they're difficult cases. But certainly, if there was something that reasonably should have been protected with the course of tests that she was undergoing, you know, that could lead to a medical malpractice or medical negligence type of lawsuit. But it's a bit of a stretch, right? Because they're not, unless there's signs of abuse, they're not exactly looking for abuse. This is a wild one, Julie, and one would think with him being a dentist and some level of a high-profile dentist, that eye drops wouldn't have been his weapon of choice, right?
Great point. Great point. Yeah.
He had access to other things.
Right. It's a really good point. John Phillips, okay, would you use that in your defense? Let's say you're defending this guy.
I mean, you throw whatever you can at the wall. You know, hey, murder for hire. I represent Joe Exotic. So I've seen government misconduct. Like, we have a motion for new trial pending before the appellate court where there was significant government misconduct. But just because you get caught doesn't mean it's government misconduct. And so they're already kind of showing that their defense strategy is a little bit desperate. But you know, you do whatever you can when you're trying to, you know, save a man from a life in prison.
Sure. No, appreciate that, John. Let's take a look together at some of the digital evidence that the investigators collected against Dr. James Craig. They really dug into the search history. According to the affidavit, a detective found this after accessing his Google account. Quote, beginning on February 27, 2023, we observed that the user had conducted searches related to poison. Those searches included how many grams of pure arsenic will kill a human, and is arsenic detectable in autopsy? Later in the affidavit, there's some more interesting stuff. Look at this. The search history provided YouTube searches for top 5 undetectable poisons that show no signs of foul play, how to make poison, and the top 10 deadliest plants. They can kill you. Oh, Manuel Gomez sounds like a smart guy doing some research, but not smart enough, apparently. The cops are smarter. Your thoughts?
Well, I mean, you know, when I see this case, it also brings me back to the Walsh case. Because, you know, in the Walsh case, what do? The guy was looking up online what to do to, how to bury a woman, how to cleaning products used, and so forth. And in this case, he does exactly the same thing. He goes online, and this is the damning evidence that I know is going to find him guilty, and showing what type of poisons, how to kill my wife. And this is something that I'm seeing, unfortunately, to be in a pattern with a lot of these sophisticated killers. They're using the internet, and that is their downfall. And I think this is one of the reasons why his attorney left. His attorney left because there was a conflict of interest. He knows his client is guilty, and he knows his client is continuously doing things to violate the attorney-client privilege. And this case is just, you know, a travesty that, you know, we have a guy like this doing this to such a decent person, and unfortunately, you know what? He killed her. But the damning evidence that's going to be his downfall is that computer. There is no doubt, just like in the Walsh case.
I appreciate the comparison. Thank you, Manuel. So James Craig's legal problems don't stop there with the homicide case. Apparently, just last week, he picked up more charges. He picked up, I believe, prosecutors filed 2 new charges against him: solicitation to commit murder and solicitation to commit perjury. John Phillips, I know you're cringing here. Officials say that he was orchestrating the murder of one of the detectives on the case. They allege that he was doing this from his jail cell as he's awaiting the homicide case involving his wife. How does that exacerbate the situation for you as an attorney if you're representing this guy?
That's probably why his attorney withdrew. You know, once you have one problem, okay, let's try to get you out of that problem. Oh, you're going to now try to do a hit on the guys that we need as witnesses, and you're going to destroy my case and my ability to operate under the rules of professional, you know, and put me in ultimate conflicts where I'm almost in the position of being a co-conspirator to not just one murder for hire, but now 2 or 3, and it's terrible. And when you have a client like that, the only thing, you know, professionals do is withdraw. But on the same token, you know, he has a right to counsel under the U.S. Constitution. So somebody's going to have to pick this up, probably a public defender, or, you know, depending upon, well, I mean, I guess he has assets. They'll probably, you know, keep trying to hire somebody. But it's crazy, you know, this doesn't reek of, again, I've dealt with government conspiracy cases where they're just throwing stuff at the wall over and over. This just sounds like a kind of a guy that's just in over his head, and he keeps putting sand on top.
Mm-hmm. Right. He was having affairs is the allegation. So get a divorce. You want to go running around and be single? Divorce your spouse,
6
right?
kids.
Much easier.
6 kids, too.
6 kids. It's terrible. I know. We feel so bad for the children always. This is just horrible. We've got to leave it there for now, but we'll continue talking about this case. Great insight from you both. John and Manuel, thank you. Kindly stand by, please. Still ahead, we're counting down to Melody Ferris's sentencing. This is expected to start up in just 15 minutes. Will the family drama tip the scales of justice?
Coming soon to Court TV.
It's the biggest story that we're covering. He is the boogeyman. Laurie, Daybell.
She said, I will have you destroyed.
She's got another murder trial coming up.
A social media sensation, now a suspected killer.
We will not stop fighting. We have no quit.
Sean Diddy Combs arrested on a federal indictment.
The high-stakes trials you don't want to miss. Coming soon. Only on Court TV.
The sentencing of Burn Palm murder defendant Melody Ferris is moments away. We're going to take you inside that Georgia courtroom in our next hour as victim impact statements from the defendant's children could be what tips the scales of justice as to how much prison time she gets.
I went back down to the burn pile and I took a close look at the burn pile. And I looked and I was like, wow. And then I saw what looked to me to be like a hand, like bones of a hand, like that. And that's when I just, you know, I think I went in shock.
When he got there and started looking around and like, they couldn't find him, like he was frantic. And when he called me about them after they had found him, essentially, it was just devastation in his voice.
And what about your sister, Amanda? How did she sound?
She was crying. She was crying. I mean, we were all extremely devastated.
And he goes, Amanda, like something to the tune of like, Daddy's in this burn pile. Like, I know what I've seen. I've been in Iraq. I know what burned bodies looked like. And I'm just sitting there on the phone going, what are you talking about? And he was like, there's something in this burn pile. He came over and grabbed me by the arm as hard as he could, and he got in my face.
Who are we talking about?
Scott.
Okay.
He got in my face and he screamed at me. He said, I know what I saw. I know what it is, Amanda. I think a lot of things that have happened in our family get swept under the rug, and they're never addressed. And they're not taken seriously. But a sin is a sin. And I feel like this is a repercussion of all the sins that were committed over years.
I was informed that they discovered a bullet lodged in the rib bone. I went into kind of shock, I'll say.
At that point, did you suspect your mom?
Definitely.
All right, let's talk about this. What do you think the court may give Melody Ferris, and why? I mean, really the question is, should she get parole? It's going to be a life sentence for her. That's what the law dictates in Georgia. But the question is, should it be life with the possibility of parole after so many years, or strictly life? Let's bring back in private investigator, former NYPD officer, and retired Army intelligence officer Manuel Gomez, and attorney Randolph Rice, a former prosecutor he was as well. Okay, where might the judge go here, and why? Randolph, would you start us off, please?
I think she gets the maximum penalty, and at 64 years old, I think she dies in prison. I know that seems simple answer, but that's it. I don't think anybody can come into that courtroom today and say anything that's going to sway this judge away from what he's going to do to her today, based on the facts, the evidence, and just the behavior after the finding of the body, of how she acted, the cold nature. Even during the trial, you and I talked about it during the trial. She just is, she's cold. She's sitting there with her pearls on and she has no emotion. And blaming one of her sons for this whole thing, I think she gets the maximum. I don't think she ever sees the light of day, and she stays in jail.
Randolph, I agree with everything you just said. I'm with you. Is there any reason to show mercy? Just even trying to look at this from that perspective. Manuel Gomez, can you see any reason?
No, I don't see any reason. I mean, this was a classic case of cutting my husband for the financial assets. If you look at that estate and what they had, that's the main reason why, in my professional opinion, she killed her husband. And the fact that she was so evil and despicable and epitomizes evilness to turn his body and burn it on the property, she's not going to get parole. I predict this judge will just give her, like my colleague said, a life sentence. And if she gets 25 to life, she'll be 90 years old if she makes it, which I doubt. Again, she should get no justice other than the justice she's receiving. She should get no mercy. I take that back. No mercy, because this case was just pure evilness.
Preach, Manuel, preach. I'm with you. I know we're going to have to let you go in a couple of minutes. Randolph's going to stay with us as we start the live coverage of her sentencing. So, Manuel, tell me, what did you think about the fact that she blamed her kids, in particular her son, Scott?
Well, that was a Hail Mary reach for her to try to have some type of defense, some type of appeal, because she's going to set an appeal in this case. There's no doubt in my mind. She has the money to do it. She'll find some lawyer that's willing to take on that appeal. And blaming it on her son was the only option, all right, because the evidence is overwhelming against her. And that, like I said, was just a reach on her part.
I'm with you. I call her Mean Mama Melody after I saw that defense. There goes that relationship. The holidays not going to be good for this family, and she had so much to do with that trauma they went through in her trial. We'll leave it here for just a moment as we hit our break. Manuel Gomez, big thank you to you for all of your insight and expertise, and we're going to pick up the conversation. Randolph Rice is coming with us. Please do the same. That's all for opening statements. If you like the episode, watch it again, share it. Go to courttv.com to do that.
the court is allowing redaction, as counsel indicated, in terms of some language about an arrest and extradition, but other redactions do not appear to fit underneath Rule 11.4 and so should be lifted. So the state has a chance to review that. It's just a few sentences in a brief report. And so I hope that the state can do that and we can proceed this morning to prevent any further delay. Is that something we can do?
Yes, Your Honor.
Okay.
And the state doesn't need to review all the redactions in order to stipulate. I just, for the purposes of the record and so that we have the unredacted copy, if defense counsel can get that to us as soon as possible, we can still proceed today.
All right. So with that, are the parties prepared or willing to stipulate to the two mental health expert reports?
So I just want to make sure I will provide a copy where we can leave in the redaction on page 2, take out the other redactions, send that to the state, and then move forward. Yeah.
That's correct.
Okay. And as far as stipulating a competency, just so that the record is clear, because again, we had filed to get out of here. We're here because the court placed her placed her in Rule 11 on its own motion. That's why we didn't fill out the form and have that prepared.
Right.
We do agree that there's 2 competent reports and would like to move forward, and we just as defense don't necessarily want to technically stipulate, but we will. Does that make sense?
Not really, no. Because there's really only 2 avenues here to proceed. You can contest that she's competent and we can have an evidentiary hearing and you can present your evidence, or the parties can stipulate to the reports which do find her competent.
Let me just say this. We are willing to stipulate. It's just we want the record to be clear that we're here on the court's motion and not a defense motion. But we are stipulating the competency so we can move forward.
Right. But nothing in filling out a stipulation form would reflect that you're here on your own motion or that you agree with being in Rule 11. So that would be how I would suggest we proceed. Is that something defense is willing to do? All right. We've got stipulation forms in front of you in that basket right there. And so you can fill that out. The state's agreeing to stipulate to the reports.
That's correct.
Okay. The court is not yet in receipt, but will be in receipt of a stipulation as to the defendant's competency based on the written reports here by Dr. McGady, dated November 7th, 2024. Dr. Webster, dated December 2nd, 2024. Stipulation having been accepted, the reports having been considered, the court finds the defendant understands the proceedings, is able to assist counsel in her defense. The court further finds the defendant competent pursuant to statute. It is ordered affirming prior release conditions, and we'll get you a new date in front of Judge Boreski so you can proceed in your case. Judge Boreski indicated he can get you in tomorrow at the earliest at 8:30 or 9 a.m. Does that work for counsel?
Yes, Your Honor.
Okay, so I'm remanding this matter to Judge Boreski's division. We'll set it as a status conference tomorrow. That's December 6th at 8:30 a.m.
last month because one of them was in pain. It led to a police investigation and criminal charges for Province and her boyfriend, Bobby Bender. And Allegheny County Police in Pennsylvania say drugs are a part of this. This started back on November 4th when Province took her 2-year-old son to Children's Hospital because the boy was having leg pain and swelling. The criminal complaint states it was determined by the ER doctors that the 2-year-old had suffered a severe femoral fracture to his right leg. Due to a concern for abuse, the other child was also evaluated by Children's Hospital doctors. The other child was identified as a 3-year-old male. The 2-year-old is identified as John Doe 1 in the complaint, and the description of his injuries is so incredibly sad. The injuries are listed as a 10th rib fracture, a femur fracture, a tibia fracture, a metatarsal fracture, which is part of the foot. Other injuries listed, 2 humerus fractures, which are bones in the upper arm, a scapula fracture, which is in the upper back. Doctors also found cell death in the brain, multiple cuts and bruises, and the child tested positive for cocaine. It's just unbelievable, that poor little boy. So with all of those injuries, which are horrific for a 2-year-old boy or any child for that matter, police say that little boy tested positive for cocaine. And because of his injuries, doctors examined his 3-year-old brother. The 3-year-old's injuries were listed as a clavicle fracture. That's the collarbone on both the left and right side. Also, he had a 10th rib fracture, according to the complaint, and neck ligatures. This is horrible too, but that last part about neck ligatures is terrible. That means the child showed signs of strangulation. Detectives wrote, according to Dr. Clayton, all of these injuries were in various stages of healing, ranging from 1 week to approximately 3 months. Dr. Clayton also informed us that all of these injuries would have caused extreme pain to the children and would have been noticeable. Dr. Clayton further stated that all of these injuries were inherent of child abuse and would not have been accidentally inflicted injuries. The complaint says detectives interviewed Haley Province, and she told them that her sons were primarily with her and her boyfriend, Bobby Bender, and that since she and Bender had moved in together in July, their relationship had changed. The complaint said, when asked what she means by that, Province elaborated and explained that he has become more physical with her and that the two of them argue and fight a lot. The detective said Haley Province also noticed bruises on one of the boys after leaving them with Bender. And you'd think that might have prompted some questions. Now listen to this part of the complaint. According to Province, she noticed that Doe 1 would not put weight on his leg the week prior. Based on Province's statement, it is estimated that this would have occurred on October 28, 2024. Province explained that she went to the store for approximately 45 minutes, leaving the children in the primary care of Bender. When Province returned from the store, she stated that Doe 1 was sitting on the floor playing and would not stand up. She stated that she then put him to bed at approximately 1830 hours and did not wake him until approximately 0900 hours the following day. Province said that she provided Doe 1 breakfast in bed and then proceeded to get him up for the day at approximately 1200 hours. When Province attempted to have Doe 1 stand to put clothes on him, he would not stay standing and would not put weight on his right leg. Province also stated that Doe 1 was fussy and crying the entire time she would attempt to have him stand. Province then provided no care for Doe 1 from October 28, 2024 until her, Province's grandmother, instructed her to go to Children's Hospital on November 4th, 2024. Detectives then questioned Bobby Bender. Detectives said Bender told them he used cocaine, but he only uses soft, while Province used crack. He also claimed that he hadn't used cocaine in 2 weeks and didn't use it around the children. Detectives say they did a search warrant on the apartment where Bobby Bender and Haley Province lived with the 2 boys, and they found a bag with white residue believed to be cocaine and a straw. And they also found a cell phone with the following text message that led them to believe Bender and Province were not only using cocaine, but also selling it. Someone named Mikey Barr was messaging their phone. Mikey Barr says, "Yo." Bender and Province's phone responds, "What's up, brah?" Mikey Barr responds, emoji of snowflake. Bender/Province respond, "How much?" Mikey Barr responds, "How much?" Bender and Province respond, 100. Mikey Barr responds, "It gas?" Bender Province responds, "Fire." Mikey Barr says, "Meat?" Bender and Province face several counts of aggravated assault, endangering welfare of children, and conspiracy. The cases I cover each day for you here on Crime Fix show you just how scary the world can be. And one of the scariest things that can happen is if you ever get hurt. But I want you to know, if you're ever seriously hurt or in an accident, your case could be worth millions. That's where our sponsor, Morgan & Morgan, comes in. The firm has an army of more than 1,000 lawyers who will fight for what you deserve, and they have the track record to prove it. In the past few months, Morgan & Morgan has won big verdicts, like $12 million in Florida, $26 million in Philadelphia, and $6.8 million in New York. All were much higher than the highest insurance company offer. Seeing if you have a case can be done in 8 clicks or less, and you don't even have to leave your couch to start one. Also, a really great thing, you only pay Morgan & Morgan if you win. There are no upfront fees. So if you're ever hurt, you can easily start a claim at forthepeople.com/crimefix. Marian Bracha is a Temple University professor and also a former child abuse and sex crimes prosecutor. So Marian, your first thoughts on this case?
First thoughts are that it's an all too common occurrence, and that these children really need a voice and an advocate because they are of an age where they are probably not going to be able to testify or to report what happened to them. So I really, really hope that there are systems in place that will make sure that they have a voice in the process.
You know, you said it's all too common, and I feel like we do way too many stories about children being abused or killed, heaven forbid. Thank goodness these children got to the hospital when they did. But what's kind of bothers me about this, or what really bothers me about it, is the fact that Haley Province, according to the criminal complaint, had to be told by her grandmother to take the 2-year-old to the hospital. I mean, the kid could not stand on his leg and was having so much pain. And she had to be told to do this. And it still took some time for her to take the child to the hospital.
Right. Denial, I suppose, is a powerful thing, or fear of consequences. But I think in this situation, we can all say, thank goodness that there was someone like Grandma who was there, who was the voice of reason, who was something of a Jiminy Cricket, lending a conscience to the situation to make sure that this child did receive some care. Better late than never, unfortunately, but let's thank goodness that there was at least someone looking out for the best interests of the children.
Mm-hmm. The 2-year-old had some really serious injuries. I mean, it wasn't just the leg injury. There was a 10th rib fracture. There was some brain, it sounded like some cell death in the left side of his brain. So it sounds to me as if this child, I mean, I don't know what happened because I'm not an expert in this. You would be more somebody who would be an expert in this, though. You know, the cell death part in the brain really, that's very concerning. Did the child suffer a head injury? Was the child shaken? I mean, this is some serious stuff. And it sounds like the 2-year-old bore the brunt of these injuries, according to the complaint.
Right. And I think what it also indicates is that this abuse wasn't a one-time thing. This wasn't just a single critical incident. It sounds like this was ongoing because these injuries were recent and some had begun to heal and heal over. So it tells me that this was activity, that this was abuse that was certainly not just a one-time thing, and it had unfortunately been course of conduct. And I think that was reflected in the criminal complaint because the endangering the welfare of a child charge was charged as a felony, which typically means that it was charged as a course of conduct, not just a one-time incident or event, but something that was occurring over a matter of time.
Haley Province, according to the investigators, said that the relationship had soured or become more intense after she moved in with this Bobby Bender. And really the implication here is that Bobby Bender injured these children. She certainly didn't admit to injuring the children, but it's implied that he possibly did this while left alone with the children because the children were either in her care or in Bobby Bender's care. And she talked about him becoming more frustrated and them arguing a lot more after they moved in July. So obviously, you know, the cops are putting this, she's charged as well. So they're putting this also on her.
Sure. And I think that from what I saw in the complaint, that is a fair charging decision, that She is a parent. She has the responsibility to ensure and to protect the welfare of the children by keeping them from medical care for any amount of time when it was needed. That would certainly fit the statute for endangering the welfare. But more than that, keeping them in a situation and putting them in the care of someone who she knew or reasonably should have known would have caused injury or was causing ongoing injury to these children was just as, in my opinion, just as much a criminal act, or could be shown to be just as much a criminal act as actually inflicting the blows herself. There's also an argument to be made that in not taking the children for medical care, that she participated in something of a cover-up, and even a cover-up after a crime is committed could lead to a conspiracy charge, because if there was a meeting of the minds of two people to do something wrong, to do something criminal like hide evidence of abuse or keep a child from the necessary care, that was the formation of a conspiratorial relationship.
Yeah, and they are facing a conspiracy charge. There were fractures in the upper arm of the 2-year-old, multiple cuts and bruises, and also the child tested positive for cocaine. So, 2-year-olds are busy. We know that. So we don't know if this 2-year-old somehow accidentally ingested the cocaine. They said that they found a straw in a bag with white residue in the apartment. So the child could have accidentally gotten into the cocaine, or I don't know, are there other ways that the child, heaven forbid, I would hope that somebody would not have actually given a child, a toddler, cocaine.
Well, my response to that is, why is there cocaine in any kind of residence with a child where a child would have access? And so to me, it doesn't.
All right, let's start back on time after lunch tomorrow. If somebody needs a place in the courtroom to meet during the lunch, we'll find them a place, okay? Is everybody ready? If so, show the jury in. Do you have your witness lined up? Your witness located? Okay. I hope y'all had a good lunch. Y'all may have noticed that we consulted the Oxford Historic Preservation District about window shades, and we haven't heard back from them about whether we've got the appropriate window shades. And, for the temporary, we're going to use this black plastic, okay, and make it help y'all viewing and temperature better. Anyway, I trust no one had any problems with the court instructions not discussed the case. That being said, who would the state call as its next witness?
At this time, the state calls Ben Douglas.
Ben Douglas?
Yes.
All right, come around, Mr. Douglas, and be sworn. Proceed when you're ready.
Please state your name to the jury.
My name is Benjamin Douglas.
And how are you employed?
I work for the University of Mississippi Police Department. I'm currently on assignment to Lafayette County Metro Narcotics.
And what's your rank?
I'm a sergeant.
Okay, so Sergeant Douglas, how long have you worked for the University Police Department?
Approximately 6 years.
And you just said that you do, you're on loan to Metro. Explain that.
I'm on assignment, so
Okay,
I've been assigned to Lafayette County Metro Narcotics. So I have a time frame that I'm not working at UPD every single day. So right now I'm working for Lafayette County Metro every single day. It's a task force for the entirety of Lafayette County for specifically narcotics cases.
So let me take you back to July 2022. Were you working with the University Police Department at that time?
I was the detective sergeant.
And did you become involved in the case investigation into the disappearance of Jay Lee?
Yes, ma'am.
Tell me, how did University Police Department become, tell me what you did. How'd you become involved?
So on the night of July 9th, I received a phone call about 8 o'clock from Lieutenant Herrington. She asked me to come to the University of Mississippi Police Department to assist with a welfare concern that was ongoing. Jimmy J. Lee had not been heard from by his parents for an extended period of time, and they called for welfare concern. At the university, we do welfare concerns pretty often. They call if a parent is worried about their kid. They'll call. They'll ask us to go and just check on them. And so we go to Campus Walk, or an officer went to Campus Walk and attempted to make contact with Jimmy J. Lee on the night of July 8th. They were unable to make contact. They found his door ajar. They went in, didn't find anything, didn't find him there, didn't see anything disheveled. So they just secured the door and left. They tried to make contact with him throughout the next day. But were unable to. And so around 5 o'clock-ish, Lieutenant Herrington was called and asked to come to the police department. And at around 8 o'clock, she called me.
Okay, so once you became involved, what did you do?
When I got there at 8 o'clock, I went to...
Just to be clear, what date was this again?
July 9th.
Okay, so when you became involved on July 9th around 8, continue on.
On July 9th, whenever I got there around 8 o'clock, I was informed that they had done a single ping on Jay Lee's phone, but that they hadn't done any further pings, trying to get location data off the phone.
Before you go any further, explain, when you say...
Object to this as far as ping information at this time, unless predicate's been laid for it.
I'll sustain objection.
Could you explain what a ping is? Is that what you're referring to? You just said you did a single ping. Could you explain what that is?
So your phone connects to cell towers. Those cell towers give location data associated with when your phone connects to them, and then it gives basically a margin of error as to where it could be, where the phone could be.
We talked about this pre-trial as to whether or not any particular witness.
At this point, I'm going to limit the testimony until we have further discussion about whether they recorded any pings or not. Okay, and then we'll probably have some more discussion, but I'm going to let them talk about whether any pings were received or not.
Thank you, Your Honor.
I wanted to hear, I couldn't hear Your Honor very well. What was the...
I'm going to let him talk about whether any pings were received at this time, and we'll have a further discussion before we get any deeper than that, okay?
Okay. So you're explaining that it connects to cell towers and within a margin of error. I'm not sure I know, what does margin of error mean?
It's basically like, we're going to tell you this, we're going to give you this latitude and longitude on a piece of paper.
I'm going to limit his testimony at this time to whether or not any pings were received on this phone. is what-
Okay, when you are going to get a ping, what information do you provide?
When I'm going to go get a ping, I give the phone number. So I call AT&T Global Legal Demand Center. When I call them, they ask, I tell them that it's an exigent circumstance. I explain the circumstance to them, and I provide them a phone number, and they will send back a ping on the phone.
So tell me, what phone number did you provide?
I provided Jay Lee's phone number, which is 601-622-2553.
And how did you know Jay Lee's phone number?
We have regular access to student phone numbers through the Student Access Portal, the SAP system.
The SAP system?
So
that's the Student Access Portal.
So whenever students enroll at the University of Mississippi, they give data to the university. Part of that data is of cell phone addresses, things like that. The university keeps those records so that they're able to contact their students.
And did you all receive any ping data?
Whenever I called initially, I did not receive a ping. They sent me an email that said that the phone was an AT&T phone and was there, but there was no location data associated with the ping. While I was talking with the AT&T, the person at the Global Legal Demand Center, he told me that it seemed that the phone had been inactive for too long, and so there was no location data associated with it. So I asked him if there was any way for us to get historic pings through exigent circumstance. And so he provided me with historic pings on Jaylee's phone from 12:17 a.m. on July 8th to 7:28 a.m. on July 8th.
Before you go any further, when you say exigent circumstances, explain what that means for anybody who might not understand.
So an exigent circumstance is just an emergency. Him being missing, it could be any number of things that have happened to him. And so because there's an emergency circumstance, we need to be able to get in contact with him because someone else is concerned or has a reason for concern. We do not have to get a search warrant in that moment. We are able to get it through exigency.
And so here you did receive pings, you said, from July 8th from 12:17 a.m. until 7:28 a.m. Your Honor, may I approach the witness?
Okay.
This is Your Honor, may I approach the witness? Okay. Sergeant Douglas, look through that and tell me, do you recognize that as the exigent circumstances ping data that you received? I believe you said July 9th, 2022?
Yes, ma'am.
Okay.
And yes, ma'am, this is it.
Okay. And has it been altered in any way since you received it on July 9th?
No, ma'am.
Okay. And it accurately represents what you received?
Yes, ma'am.
Your Honor, this time I'd like to have it marked for identification purposes only.
It's going to be S22. It'll be marked for ID. Only, just
Thank So you have a copy up here. Okay. So from those pings that you received, were you able to develop any leads in that data?
The final 2 pings that we received were at 7:28:27 a.m.
Responsive to the question, objective.
I'm not sure I understood the question anyway, so I'm gonna let her repeat the question. And then,
I said, were you able to develop any leads from that data that you received?
answer yes or no, and then we'll go from there.
Okay.
Yes.
Okay. And were you, from those leads, you said it's to find the phone's location. Were you able to develop where the phone could have possibly been between those hours to for Jay Lee?
We were able to get multiple pings over the course of this time between 12:17 a.m. and 7:28 a.m. Some of those pings.
What between when and when?
12:17 a.m. and 7:28 a.m. on July 8th.
12:17.
12:17 a.m. to 7:28 a.m.
Okay.
Okay.
I figured it's going to be a later, so I won't get it right this time anyway.
And was there anything from what you know about the investigation on July 9th, was there anything you said, when did you said they told you the phone was no longer transmitting. When did it stop transmitting?
The final ping was 7:28:27 a.m. on July 8th.
Okay. So would it be important for you to find out where it was when it stopped?
Yes.
Okay. And why would that be important?
Because people always have their phone on them. They travel with their phone in their pocket. We also, later on in the investigation, we determined that he had his phone whenever he left his apartment.
Okay. So when you receive this data, what is it that you receive? Like, what actually is it?
It's a series of latitudes and longitudes that also have a timestamp and a margin of error, an area that they mark it as location accuracy, how accurate the location may be.
All right, I'm going to ask the jury to start walking off a little line and go back to the jury room, okay? All right, I'll hear you on your objection.
Similar to the same objection, the witnesses in the courtroom would ask them to step out. Witnesses in the courtroom, we ask the witness to be excused during argument.
All right, that's fair enough. If you would, don't discuss your testimony with anyone. If you would just return back to the outside there. Like. All right, I believe the witness is wrong. You can state your record. State your objection.
Two things. First of all, before any testimony that could come into play as far as the not necessarily latitude and longitude, but the range of location of the within certain areas of the ping where it would be location wise, that has to be done by an expert. First of all, that's what we talked about in written. I think the court indicated at that time that before they got any further than latitude and longitude, they would have to have an expert to testify to that, or indicated at that point when we were in written. Second thing is, under the Fleming case, and you follow Smith behind it, at one time, right now, he can only testify to what he received, and the documents are to be interpreted, and he can say, I received this information, and the purpose of that was to determine whether or not lat and long on it, and he can plot that, and that's basically it, Your Honor. Not testify about anything other than that. Fleming and Smith versus...
I'm familiar with Fleming. Are you saying that under Fleming, the witness, your opinion of Fleming, that witness can testify as to latitude and longitude?
If he's qualified to do so, Your Honor, he can testify and plot out those points as to lat and long. He cannot go any further than that as to whether or not it's within any particular range, footage, or anything like that from a person, from a location, or anything like that, or a tower. It cannot, with any specificity, say where that phone is. Now, this witness is not qualified to do that.
All right.
Respond.
Y'all, you through, Mr. Toland? I won't cut you off. And I may want to reread Fleming.
Second thing, Your Honor.
Go ahead.
It hasn't been addressed or marked as an exhibit yet, but I understand, I think we need to go ahead and address it while the jury is out, that I think the state is anticipating trying to get a certificate of authenticity on these records that was submitted to us last night, I think 4:45 by email. That certificate of authenticity, had it been produced earlier, would only allow a witness qualified to do so to testify about some of the lat long information and how it relates to particular locations and the range that he was attempting to talk about before we cut him off. That's an untimely 902 11C2 certificate. We got it yesterday, and we would object to any admissibility of any documents for the purpose of either that record of authenticity certificate or any other AT&T documents coming into evidence that would represent to the jury any particular information about within whether location of persons, locations of cell towers, or locations of whether or not what the margin of error was for the location of the particular ping location, if that makes sense to you, Judge.
I'm familiar with your argument, and I'm going to listen to the state, and then I'm probably going to take a minute and look at Fleming's again, okay?
Yes. Your Honor, I didn't actually anticipate.
Let me ask before you get into your argument, so we know what we're arguing about. What testimony do you anticipate eliciting from this particular witness?
Just latitude and longitude. I actually wasn't, when we spoke about it, we didn't talk about margin of error. I actually am not attempting to ever introduce it into evidence. It's just marked for ID because it's just being used to show how he developed investigative leads. It's all leading somewhere.
Are you going to limit this witness testimony to latitude and longitudes pings during this 7-hour or so time frame?
Yes, Your Honor. But I would also, that is what I'm going to do. And I would point the court to the Collins case, which I don't know.
Let me, before you start that, as I understand that the defense does not have any objections to latitude and longitude information if it stops there with this witness?
That's basically, as long as he's already testified, Your Honor, that this identifies where a person is. They cannot say that clearly under Fleming. They cannot testify that the person's with the phone.
I'll be limited to whatever it is where the phone, latitude and longitude of a phone.
Of a phone. That's clearly what Fleming says, and Your Honor, I guess I'm not.
Can I respond?
Hold on one second. Mr. Douglas was provided in the 1121 discovery disclosure. I will say none of his testimony or summary of any of these statements were provided to us that he would be giving this type of testimony. Based on the discovery violation, we would object to that as well. I understand that I'm making the same discovery responses. His name was provided in discovery. but his testimony that he was going to provide Latin long information at trial is nowhere in any of the discovery material. Okay? I want to be clear on that.
I understand. I'm going to.
Notwithstanding that objection, if the court overrules that, the law is clear that he can testify he received the phone records and phone records have Latin long.
Did the defense receive this latitude and longitude information in discovery?
We received, again, Your Honor, you got to understand, we received that information. There's no association to Ben Douglas anywhere in it, other than the fact that he received it. Not that he was going to, as far as the Latin long.
The defense received the information that in discovery that Ben Douglas received latitude and longitude information
In April of 23 on that particular information.
Okay. I'm going to overrule your discovery violation objection. And now if the state is attempting to only introduce latitude and longitude information through this particular witness, is there an objection to that?
No.
All right. Is that what if you're going farther, I need to know it. But
I want to clarify, when you say latitude and longitude information, you mean he's going to say where that latitude and longitude points to? Is that what you're saying? Like,
somebody let me look at Fleming and see if.
I have the Collins case, which I wanted to provide to the court.
All right, I'd like to hear that.
Okay, thank you.
It doesn't. I don't think it takes a rocket scientist to coordinate latitude and longitude if they have that to a spot on Earth anyway. But go ahead.
That's all he was going to do: coordinate latitude and longitude, and we were going to introduce it. We're not introducing it, just ID only to show how he went along with the investigation. That's all he was going to do, and then he was going to coordinate it and say this was here and this was here. We weren't talking about.
Let's just say that latitude and longitude is latitude is X and longitude is Y. Do you anticipate saying latitude is X and longitude is Y? Y is around so-and-so apartments around.
No, it wasn't going to say so-and-so apartments. He was going to say, where's my note?
Judge, let me clear up what I'm saying. I want to make sure everybody understands. Latin log says that's where that ping location is. It doesn't really tell you, it says where the ping is from the phone. There is a range where that phone could be. He can only say that ping is coming from that location. He cannot say that's where the phone is. He can't say that's where the person was. Or you can't say what the range was, what the phone was within that range. You can say, yeah, they sent me this information.
I'm going to let him say that the latitude and the longitude for this particular ping, where that latitude and that longitude cross is at a certain place in Fayette County, Mississippi.
Don't have a problem with that.
Okay,
His testimony can only be that the ping information that he got. He cannot testify that phone was at that location, just the ping information.
I'm going to allow that. I'm not going to let him, this particular witness, expose opinions on how close that may be, what's the margin of error and things like that. I don't think he has that in his expertise.
His testimony cannot include language that says that's where the phone was. The ping represents where the phone was. That's not that.
I think that would be a correct statement. This witness can testify as the information he received, that the latitude and longitude of the ping would direct you to a particular, I assume in Lafayette County, a particular spot in Lafayette County, Mississippi, and go from there.
He can testify that there is a margin of error, but he can't tell anybody what it is.
All right, I'll let him do that.
I didn't ask him about a margin of error, Your Honor.
He was trying to volunteer it whether he asked it or not anyway. So
that's all we're planning on getting into.
I think we know where we stand anyway.
Thank you.
Somebody. Lindsay, would you grab our witness for us?
Can I have my pen up? We running out of paper.
No, I'm saving. Uh-oh, sorry. I'm probably gonna need that again for today, so.
Too much law.
That's all
All
right.
right. You got Fleming's, thank you.
Can we instruct the witness beforehand?
What's that now?
Can I have a moment to instruct the witness regarding what he's not supposed to say? Or
Yes, please do. Okay. While the jury coming in, I want y'all to be getting y'all's thoughts together on scheduling over the course of the next few days anyway. When we're gonna work, when we're not gonna work, and that kind of thing. Your thoughts on it, not when we're gonna do it, but your thoughts on it anyway. You ain't got no insurance, don't fall. All right, you may resume your direct examination.
I believe where we left off, Sergeant Douglas, is when was the Jelly's phone stopped transmitting, or you could no longer receive pings?
Yes, ma'am.
When was that?
That was at 7:28 a.m. on July 8th.
And you received latitude and longitude information in the from the phone from AT&T, correct?
Yes, ma'am.
Okay, for the last location of the ping, right?
Yes, ma'am.
Okay, and what were the last two locations, the ping locations?
The last two locations, the 7:28 a.m. ping, the 7:27 a.m. ping was near Stone Park, and the 7:28.
We talked about that, John. You can give latitude and longitude only.
Said he could say it.
I'm going to let him. I think he can testify as to where that latitude and longitude intersect on the Earth.
As to the ping on.
I don't know exactly what.
Same ping.
I think he was saying ping. You limit your testimony to where the ping came from, okay?
Yes.
I think that's what you did, but go ahead.
Yes, so the ping, the direct ping, the last two pings, the 7:28:27 a.m. ping on July 8th is near Stone Park, which is across from the Oxford Police Department. And the 7:28:26 a.m. ping is near Residential College South, which is at the intersection of Gertrude Ford and Jackson Avenue. So in relation to...
Well, I'll ask, how far is Molly Bar Trails from Stone Park?
approximately half a mile.
And how far is Molly Bar Trails from Residential College South?
Approximately 1.5 miles.
Now, you said you were doing this because, Jelly was missing, it was an emergency, and we're hoping to find him as people usually keep their cell phones. What did you all do? The phone was off, or wait, before I get into that, you said they told you it stopped transmitting. Did that mean it was off? What did that mean?
It could be off, it could be broken. It's just not transmitting to cell towers anymore. So the cell towers are not receiving anything.
Okay, so it was just not there anymore. Okay, so how did your investigation proceed forward beyond the pings?
So after the pings, we continued looking for, the University Police Department continued to look for Jay Lee, look for his vehicle, look for things that we knew were associated with him. Then on July 10th, Lieutenant Carradine conducted an interview with Jose Reyes. I sat in on that interview. After that interview, I wrote a search warrant for Jay Lee's apartment.
Okay. Did you actually go to the search warrant while it was being executed?
Yes, I did.
Okay. And I believe we've already sort of heard testimony regarding that. So following the search warrant on July 10th, had Jay Lee been found?
No, he had not.
So what were the next steps for you in your investigation?
Next steps were, I filed an exigency request with both Apple and Google. So I filed an exigency request with Apple for information associated with Jay Lee's Apple iCloud. We didn't have his phone at this point, but Apple iCloud is integral to iPhones, and we knew that Jay Lee had an iPhone. We also knew Jay Lee's Gmail account, and so we sent an exigency to see if that Gmail account was associated with his iCloud account.
So tell me, what was your purpose for sending these two exigency requests? Like, why did you do that in the investigation?
We wanted to see if they had location data that they would send us in the immediately, like just immediately, because we were trying to find him. We also wanted to see if anybody had called him, if anybody had texted him. We were trying to just get generalized information that would help us find Jay Lee, find where he was at, if we could.
And at this point in the investigation, did you have any information that you believe would make that relevant?
Can you repeat that question?
At this point in the investigation, did you have any information from witnesses or footage that would make that relevant, or anything?
Yes. Other officers had spoken with Khalid Fears. Khalid had told them that he was on the phone with Jay Lee the night that he went missing, that he was about to go to a hookup with someone that he had previously blocked.
And did you have an opportunity to view any footage that might have corroborated that?
Yes, I saw campus walk video footage of Jay Lee leaving his apartment. He leaves the apartment on his phone, and the door doesn't close all the way behind him, just the same way that officers found it whenever they arrived.
And did you later get a search warrant, or well, let me approach. May I approach, Your Honor? If I approach, I should show you that.
She's asked to approach.
Okay.
May I approach the witness?
You may.
Sergeant Douglas, do you recognize what I'm handing you?
Yes, ma'am.
What is that?
This is the Apple iCloud exigency form.
Okay, and is that what you received when you requested this back? I believe you said July 10th?
This is what I sent to
this
Apple
is what you sent. Okay.
to receive information back.
Okay. And has it been changed in any way?
No, ma'am.
Okay. Your Honor, at this time I'd like to have the Apple exigency marked for ID.
All right. For ID purposes, fine. S23. Is that the warrant or the return?
This is just the what he requested, his request. Sergeant Douglas, did you at all follow up on, I believe you said something to Apple and to Google. Did you follow up on that?
Yes, we received the exigencies, but we eventually wrote search warrants for the information associated with Jaylee's Apple iCloud account and his Gmail account.
Okay. And when you received, did you receive information back from either of those?
Yes.
Okay. Your Honor, may I approach the witness?
Right. And you don't have to ask every time. I don't think y'all gonna fight or anything.
Stack. Accidentally got it. This was full search warrant by this was the Apple agency request.
Everybody good over there?
Apple search warrant on for Jaylee's iCloud, I believe. Yes. This is the Apple for his iCloud, yes. And then, hold on a second. I didn't get that one. Sergeant Douglas, you recognize what I've just handed you?
Yes, ma'am. This is the search warrant for Jaylee's Apple ID information.
Okay.
Or iCloud information, excuse me.
Is it the return?
No, this is the physical search warrant for the Apple iCloud.
Oh, okay. Yes, I'm just going to do return. And is that in a substantially similar condition as when you submitted it?
Yes, it is.
And has it been changed in any way?
No, ma'am, it is not.
Okay. Your Honor, at this time, I'd like to have it marked for identification.
In the Apple iCloud return,
Search warrant.
warrant itself, of the return.
Just the IDs.
This S24 that's next, is that the iCloud return or the iCloud warrant?
Warrant.
Okay.
And you received information back from the Apple return and from the search warrant, correct?
Yes, ma'am.
Okay. Tell me what relevant information did you receive?
We found a phone number inside of the return that returned to Tim Herrington.
Let me show you this.
Anybody know any good jokes?
So, I think I'll actually put one down. Okay.
Sometimes this work is tedious, I'll say that anyway.
Sergeant Douglas, oh.
You didn't use that one. I couldn't read it. He read it.
Sergeant Douglas, do you recognize what I handed you?
Yes, ma'am.
Okay, what are the two things I handed you?
You handed me Apple message logs from the search warrant and a note that I found when going through the iCloud note data.
Okay, does that accurately reflect two of the items that you received back to the Apple search warrant?
Yes, ma'am, it does.
And has it been altered in any way?
No, ma'am.
Your Honor, at this time, I would move to enter those two items, the message logs he just referred to and the note from JB's iCloud account into evidence.
Message log, and the other thing was?
A note, like a note, and I'll let you explain what the note is.
So the note has, when going through Jaylee's iCloud account, there's a lot of information, a lot of data. One of the things that iCloud stores is your notes. So whenever you take a note on your phone in the Notes app, it's stored in Apple iCloud. Whenever we were going through those notes, we found a note, just like many people do, where he started writing down passwords associated with certain things. One of those things was Snapchat. We found a note that specifically said Snapchat and then had passwords written out next to it. And so we, when we found that, we downloaded the note, printed it off, so that we would be able to access his Snapchat at some point.
Okay, at this time I would have it, the note and the message log moved into evidence.
Is that a composite, S25, both are two different items?
I would do a composite, Your Honor. Yeah.
Any objection?
Not without waiving my previous objections, but as far as this
Okay.
point, I'm no
Previous
objection.
noted. All right, is that S25, two documents? S25, all right, we'll be admitted.
Your Honor, may I publish the jury?
You may.
Okay. So, Sergeant Douglas, you just testified about a phone number that was related to Tim Herrington that you received.
Stipulate to the phone number to be worded out in the courtroom.
Oh. You'll, yeah, you're right. He still has the same number. He still has the same number. Okay. So, without saying what Tim Harrington's actual phone number is, just B, I would like you to look at, is it showing on your screen?
Nobody's, I don't think. In all likelihood, if it'll probably be shown to the world anyway. Don't show these phone numbers on the media at this time, okay?
Sergeant Douglas, are you able to see that?
Yes, ma'am.
And remind us again, this was from Jaylee's Apple search warrant, like the phone.
Yes, ma'am.
Okay. And you highlighted 2 times. What are those times?
In Central Time, they're going to be 2:54 a.m. in Central Standard.
You said in Central Time. When you received this, what time was it in?
I believe PDT is Pacific.
And our time zone is Central.
Central, yes, ma'am.
Okay, so this time would indicate what time again?
2:54 a.m.
Okay, and at 2:54 a.m., you said the phone number, which they have stipulated is Tim Herrington's phone number. What were you able to determine happened from Jay Lee's account regarding Tim Herrington's phone number?
It received some form of message from that phone number.
Could you tell what kind?
No, ma'am. There wasn't any data associated with the message. It was just, it returned on an iMessage return, so we assume it's an iMessage.
And the next thing you received, and I won't show this either, is the passwords account to Jay Lee's accounts, like different social medias.
Yes, ma'am.
And why was that important?
At this time, we had not received a return from Snapchat, but we also knew that Jay Lee used Snapchat quite often because we had talked to Khalid Fears and he spoke about how he would talk to Jay Lee on Snapchat. We wanted to know who all he was communicating with on Snapchat. We also wanted to see if there was any sort of data that could help us find him, see if there was some sort of message on Snapchat that showed where he had gone or where he was going or what he had done. We were trying to, whenever we found that password, what we were able to do is we were able to log into Jay Lee's Snapchat as though we were Jay Lee himself.
So you actually use that password to log into Jay Lee's Snapchat account?
Yes, ma'am.
Okay, and did you discover anything?
So in Snapchat, you're able to go into your settings as a user and you're able to download your own data. And so we went into it and we downloaded the data of Jay Lee's Snapchat account as though we were the user of, or the owner of the account. Whenever we downloaded that data, we were able to look at received messages. We weren't able to see the messages that Jay Lee had sent, but we were able to see the messages that Jay Lee had received. In those messages, we found texts in the time frame that Jay Lee had left his apartment that sounded as though he was going to meet somebody that he had already met. Messages like "come back."
And you said, were you able to see what user was sending those?
Yes, the username was redeye_24.
And you said around the time he was leaving. What time was that? I'm sorry, around the time Jay Lee was leaving?
Around the time that Jay Lee was leaving.
Yeah, what time was that?
Would have been around 5 a.m.-ish.
I'm sorry, I couldn't hear you. I actually couldn't hear you, but you can review your notes if you need to. Actually, may I?
Yeah,
I'll
I'm unable to remember exact times.
You said around the time he was leaving. Your Honor, I'm showing the witness what has previously been introduced into evidence as S5. So I just pulled this out.
found no login. I can't see my mouse. Oh, it's showing on there.
The first one or
I want the final leave. Showing up on the screen.
Have they got you anything except water to drink back there? Good, because I'm wanting Coke real bad. I wasn't gonna drink. I wasn't gonna drink one if y'all didn't have an option to get one as well, okay?
There it goes. I think you just have to give it a minute.
You don't want something done in the water out, stay in. Back to this, on back to that.
It was messages between 5:30 and 6 a.m.
I just wanted to get him when he walks out of his, so it's not. Yeah, I think you just have to wait for it to load. It looks weird. This isn't how, this isn't correct. This isn't correct. No. Oh, is it?
Tell Jeremy the time frame.
I'm trying to go to the last time he leaves. Is it showing for everyone?
Yes, we'll
Okay.
get time to.
Yes. Sergeant Douglas, are you able to see States Exhibit 5?
Yes, ma'am.
Okay. And have you previously viewed this?
Yes, ma'am.
And is it accurate? This represents the last time Jay Lee was seen leaving his campus walk apartment.
Yes, ma'am.
And what time was that around?
5:58 a.m.
And you were saying that you, from the logging into the Snapchat, you were able to see that messages from a Red Eye, username Red Eye, and what did it appear was happening around this time when he was walking out?
They were saying, "Come over."
Okay. And why was that important to you, that you saw around the time he was leaving, he was getting messages from a Red Eye saying, "Come over"?
Well, Khalid Fears had previously testified that, or had previously told us that he was going to meet up with someone for a hookup. So someone that he had blocked. So we assumed that whoever he was going over to, who said "come over," could potentially be the same person that Khalid was talking about.
And was there any other information in the in the Snapchat account that you thought was relevant or led to a lead?
Yes, there was location information inside of the Snapchat account.
Other than the location information, we won't be getting into that, regarding accounts that may have been blocked or anything of that nature.
Yes, ma'am. Under blocked accounts, there was an account with the username Tim Herrington.
And why was this significant?
Because Khalid had said that he was going to someone who he had previously blocked.
So at this time, what did you all do, or what did you do?
At this time, whenever we finished reading the messages, we got a subpoena to Snapchat to get the user information associated, or the subscriber information associated with the redeye_24 account.
And were you, when you sent that subpoena, did you receive any information back?
Yes, the subscriber information revealed a phone number. That phone number was a Google Voice number. It returned to bandwidth.com was the individuals that owned the domain for the phone number. That phone number was a Google Voice number, so we sent an exigency request to Google to get subscriber information associated with that Google Voice number.
So before you go on, I want to make sure that we're all understanding. This was a phone number that was associated with a website, and that website was connected to Google?
So Google has a thing called Google Voice, where you can have a Google phone number, and so it was a Google Voice number.
Oh, so would it be accurate to say that the phone number was connected to a website, but it was like whoever owned the website, or that was their Google Voice number?
You could rent out or like subscribe and have that phone number given to you via Google, just like you would do with any other mobile carrier.
And when you did that, I believe you said it went to a Google Voice number. Were you able to determine anything that was connected to, like the Google Voice number?
Yes, we got a Gmail account that was dirt2, the number 2, dirt2diamonds podcast at gmail.com. Whenever we Googled Dirt to Diamonds podcast, we found a video of Sheldon Timothy Herrington interviewing somebody.
Your Honor, may I approach? I apologize. I'm not going to ask him.
Okay. You can always approach him. Go ask over there anyway.
Sergeant Douglas, do you recognize what I'm handing you?
Yes, ma'am.
And is that the part of the return that you received when you sent the search warrant to Snapchat for the subscriber information of redeye_24?
This is from the subpoena.
Oh, from the subpoena, I apologize. The subpoena for the subscriber information for redeye_24.
Yes, ma'am.
And you sort of have already gone through it. That was connected to ultimately Dirt to Diamonds, and you Googled that, and it was a podcast, right?
Yes, that same Google Voice number had a recovery phone number that was also Timothy Harrington's.
Oh, so say that it had a
It had a recovery phone number. So a phone number, if you lose your password, it sends a code to your phone so you can get a new one. It had a recovery phone number associated with, that was Timothy Herrington's phone number.
So it was the same Timothy Harrington's phone number that we previously stipulated regarding?
Yes, it was.
Okay. So, and at this time, Your Honor, I would move into evidence the subscriber information from the Red Eye 24 account.
Which one is, which exhibit is that?
I think it's S26. S26.
S26? So that, what we call them? Has it been identified?
He identified it as what he received.
He identified it, to get a number assigned to it? I didn't think so.
I'll identify it.
Let's, pass it down to be marked as S26, and then I'll hear from you any objections.
No, I have a written objection as far as 90211 stuff that we talked about before, but I just want to make sure that Detective Douglas looks through all those documents, make sure we don't have any biographical information that may be.
All right, y'all look through that and make sure we don't have any of that, but,
I think she's taking everything out that doesn't need, I think we
we're
agree.
referring this as a Snapchat return, as I go.
It's the subscriber information for Red Eye 24 account.
Any objections other than those previously noted? No.
No, Your Honor.
All right, it'll be admitted.
And so at this time, you received that return, and kind of give us an overview of what happened. This was the Red Eye account when you logged into Jay's Snapchat that was actually chatting back and forth with him.
Yes, ma'am. This was redeye_24, the account that he was using to speak to Jay Lee that night.
Okay. And at this time, when Jay was leaving, one of the messages that you could see from Red Eye appeared to be inviting him over.
Yes, ma'am.
Okay. And that coincided when Jay was leaving his apartment at 558.
Yes, ma'am.
Okay. So at this point in the investigation, what day did that happen?
That was July 20th.
Okay. Did anything
We
happen
logged into his Snapchat on July 20th. We got the subpoena on July 21st.
Okay. So anything else of relevance happened on July 21st?
On July 21st, we also received video footage from Rockets of a white Kia picking up the individual that had run down from Molly Bar Trails.
And who was driving that white Kia? Did your investigation reveal that?
The investigation did reveal that. So on July 22nd, the PD had been looking just all day for that white Kia, seeing if they could find it. UPD found it at Campus Walk on the morning of the 22nd. A traffic stop was initiated on that vehicle, and Keziah Carter was identified as the driver.
So did Keziah Carter identify who he picked up on July 8th?
Yes, during the interview, he identified Tim Herrington as the individual that he had picked up on July 8th.
So, at this point in the investigation, what did you all do? What did you all do?
So, because we had Keziah picking up Tim running down from Molly Bar Trails, because we had the Red Eye 24 messages saying, come over, because we were able to ID Red Eye 24 as Tim Herrington, we decided that it was best to go and speak to Tim Herrington.
And you said it's the 21st or 22nd? What day is it? In July?
This was the 22nd.
Okay.
Whenever we speak with him.
You said that the footage of Tim Herrington running from Molly Bar Trails, that Keziah picked him up. Why was Molly Bar Trails important?
Because Molly Bar Trails is where Jaylee's car had been found.
And were you aware of anything about when Jaylee's car entered Molly Bar Trails?
I watched the video at some point, but I'm not aware of the exact time frames of each one of them.
But you know that it was the video Keziah picked him up coming from there?
Yes.
Okay, so you said you all decided at that point to that you needed to speak with him. Was this all in accordance also with information you had heard from Khalid Fears in the investigation?
It was. It all stemmed back to Khalid Fears had spoken about someone that he had blocked, that Jaylee had blocked, someone that he was going to meet for a hookup, and the messages have come over. So we believe, so it just added to believing that we needed to go speak with Tim Herrington.
And I believe earlier you stated when you reviewed Jaylee's block list, when y'all accessed his account, Tim Herrington, the name that was under the blocked.
Yes, ma'am.
Did you actually participate in that interview of Tim Herrington?
I did not.
So where were you that day and what was going on?
That day, I was at OPD still reviewing data and getting the search warrants for the Red Eye _24 Snapchat account.
So tell me more now about that. You said you wrote a search warrant for the Red Eye 24 Snapchat account.
So I wrote a warrant for the Red Eye _24 search Snapchat account.
Okay. And why did you do that?
We wanted to get any information that was associated with that Snapchat account.
The first thing you did was you sent a subpoena for Red Eye for subscriber information.
Yeah, I'd just like him to answer. I hadn't objected a lot of the lead, and I know this is technical stuff.
I haven't asked the question. I haven't asked the question yet.
Don't we lead you witnessing? Try to be cognizant of it, okay?
So at this time, you previously talked about getting a subpoena for the subscriber information of Red Eye 24. Why did you get a warrant also for the Snapchat and full information of Red Eye 24? Why'd you do that?
Well, all we got was subscriber information. We didn't get messages or other data that was associated with the account. And we wanted as much information from that account as we could possibly get.
And, Your Honor, may I approach the witness? Oh, I apologize.
He'll run you off from over there if he don't want you, so I'll let y'all worry about that.
Sorry, I'm so used to saying that. I'm going to take out this stuff. recognize what I've handed you?
Yes, ma'am.
What is that?
This is the search warrant for the redeye_24 and Tim Herrington account.
The one that you received on what date?
The one that I got
Oh, sorry,
signed.
the way that you the one you drafted and sent off on what
I
date?
had signed on the 22nd, like got it drafted and sent off. I received the information from it on the 25th.
Your Honor, at this time, I would move to mark this for ID, which is the search warrant for the redeye_24 account.
Be marked for ID.
Leave that as ID 27.
That was through Snapchat.
Yes, Snapchat for the red eye. So, Sergeant Douglas, you were saying that you got information back from this warrant?
Yes, ma'am.
Okay. And when you got that information back, what was the purpose again of why you wanted to get this
We already
information?
had one side of the conversation, but we wanted both sides of the conversation
Between
Jaylee Snapchat and the redeye_24 Tim Herrington Snapchat.
Sergeant Douglas, you recognize what I've just handed you?
Yes, ma'am, I do.
And what is that?
These are screenshots from the Excel spreadsheet that have all the conversations between Sucker for Jay, which is Jaylee's Snapchat, and redeye_24, which is Tim Herrington's Snapchat.
And is it the same as when you received it?
Yes, ma'am.
Okay. At this time, Your Honor, I would move to mark for identification purposes the conversations between the redeye_24 account and the Jay and Jaylee's account.
For ID only, just right?
Yes, for ID.
That'd be 28, won't it, Kathy? All right, be marked. An hour and 15 minutes, everybody good? Let me know if you're not, okay?
Sergeant Douglas, what time period did these messages go over? What was the relevant time period for you?
In Central Time, these messages are from 5:17:09 a.m. till 6:03:15 a.m.
And I believe you said in Central Time. Why did you say it like that? How do you receive the data?
These are written in UTC.
What is UTC?
I believe the term is universal time.
Okay. And to get to Central Standard Time, our time, what do you have to do?
You have to subtract, I believe, 5 hours from it.
Okay. And it also appears to be some kind of spreadsheet. Like, why is it that?
This is how it was sent to us. It was sent to us in an Excel spreadsheet. So there's an Excel spreadsheet that has tabs. One of those tabs would be the sending user, the receiving user, the text, and then the timestamp of the actual message.
And just so we're clear, these are the messages between Jay Lee and the Tim Herrington Red Eye 24 account from when to when?
From 5:17:09 a.m. through 6:03:15 a.m.
And at this time, I would move to enter into evidence the Snapchat messages between Jay Lee and the Red Eye 24 Tim Herrington account that he just testified to.
Any objection?
Other
Other than the previous objection. All right, that'd be S28, would that be correct? S28 will be admitted.
I just want to make sure for the record, I think I got a string of objections, but my relevancy objection's still moving forward. I know, hadn't heard anything about making it relevant, but I have been objecting to relevance.
Your objection as to relevancy has been noted as well.
Thank you.
Your Honor, may I publish to the jury? Okay. Sergeant Douglas, I want us to go through these messages together. Do you have the full messages up with you to read?
I have the exhibit, yes, ma'am.
Okay. If you could, tell us I'm going to show it up here, and you have for them to see, and you have one so you can look at it. Tell us who is speaking and what is being said, and the time.
Yes, ma'am.
Am I at the beginning, the right?
The beginning's at the very bottom. The beginning is at the very bottom, the very last row.
Oh, thank you. So that first message would be it. So, go ahead and tell me, what does it say?
The message says, "Who TF is this?"
And what does that mean? Who TF?
Who the fuck is this?
And who sent that message?
That was Jay Lee to Red Eye.
And you can just go on to the next one and tell us back and forth who will be speaking.
So it's Jay Lee, he says, "Who the fuck is this?" And then he sends a question mark. He then sends, "What did you delete?"
Into the microphone.
Yes, "What did you just delete?" He then sends, Jay Lee then sends, "You made it like this." Red Eye responds, "Come back at 5:25:26 a.m.
Okay. And the next message, who is that from?
Herrington sends, "You coming or nah?" at 5:26:54 a.m.
Continue on, please.
Lee then says no at 5:27. Herrington asks why not. Herrington then sends 2 question marks.
At what time?
At 5:31:43 a.m. Lee says, you just wouldn't even eat my ass 1 hour ago after I cleaned and everything. Then you proceed to nut in my mouth. Hopefully you ain't been fucking nobody raw. Then ask if I'm gonna stop harassing you now that you want to stop linking. You know how much of an asshole move that is."
What time was that message sent?
That message was sent at 5:34:40 a.m.
Not on this document.
It's at the very top.
Where's the graph? Let me show you. Okay. Now show us where it is on the document and why it's not showing fully on the screen.
At the very top of the document, it has the entire message and then it says which file it is. So it's K140.
Is this K1?
So K140. So in the middle, you can see that the row is K, the text row is K, and at the very left it says 140, so you can see that the row 140 on the very far left side of the document. And if you move over, you'll see the beginnings of it at the very top of the document. It shows the entirety of what's contained inside of that message.
Why did y'all, when you printed this out, why did you do it like that?
Because we couldn't, I wanted to, in this screenshot, I wanted to get the sender, the receiver, the sender, the text information, and then the time all in one screenshot.
Okay. And so you could tell me what time that last message you just sent, what time was that sent at?
This was sent at 5:34:40 a.m.
And if I'm reminded, what time did Jay Lee ultimately leave his apartment?
At 5.
Leave his apartment. What time did Jay? I apologize, I wasn't clear.
No objection.
What time did Jay Lee ultimately leave his apartment?
Around 5:50 a.m.
Okay, so we're at 5:34 a.m. right now. If we could go back to the messages, who sends the next one?
Jay Lee does.
And what does it say?
It says, "You fool."
And go on and continue on with the conversation and the timestamps and who's speaking like before.
After "you fool," it is Jay Lee. He says, "Like you done did some questionable shit, but that was too much." Jay Lee then says, "Have a good night, Tim."
And why was that relevant to you, that message? Have a good night, Tim.
It helps confirm that Tim Herrington is the individual that he is speaking to.
Okay. Continue on saying who is speaking, the time, and what the message content is.
The next message is from Jay Lee, and it says, "Yeah, now it seems like you just trying to lure me over there to beat my ass or something."
What about the next? And what time was that sent?
That was sent at 5:37:16 a.m.
And what about the next?
The next was sent from Red Eye, which is Tim Herrington, and says, "You trippin', I do feel bad, because we cool, I ain't trying to end it like this." The next is from Jay Lee, and it says, how we cool, and you barely want me to text you."
You can please tell me the timestamps as well.
That was sent at 5:39:10 a.m. The next was Herrington. It says, "I'm saying you're a cool person" at 5:39:54 a.m. The next is Jay Lee saying, "When the last time you've fucked somebody, don't lie." That was sent at 5:54 a.m. Herrington responded and said, "A few weeks ago" at 5:41:39 a.m. Lee responded with "raw or condom" at 5:42:14 a.m.
And we'll start again. Oh, the next page. When you pick up to the next conversation and the time and who's speaking, let me know.
So at 5:44:49 a.m., Jay Lee responds, "Only way I see you again is if I'm getting head in the front." At 5:45:14 a.m., Harrington responds, At 5:45:19 a.m., Harrington sends "okay." At 5:45:43 a.m., Lee says, "What you keep deleting, and that's it, just okay." At 5:46:21 a.m., Harrington states, I misspelled something, and okay, I'll do it." At 5:48:02 a.m., Lee responds, "YK, or you know, if you try something fast, it won't end good for you, right?" At 5:48:19 a.m., Harrington responds, "WYM, or what you mean, something fast." At 5:45 a.m., Lee states, "Like try to hurt me, or son, or some shit." At 5:25 a.m., Herrington responds, "I know." At 5:51, 14 a.m., Lee states, possibly later tonight. 5:51, 38 a.m., Herrington responds with, LOL, I just told you I'm leaving later today. At 5:53, 48 a.m., Lee states, LOL, okay, we are fixing to see if you lying. At 5:48:01 a.m., Herrington responds, lying about. 5:54:19 a.m., Lee says, making it up. 5:54:34, Lee says, I'm coming. At 5:54:56, Lee states, what that mean? At 5:55:39, Lee states, has there ever been a cent before? At 5:55:44 a.m., Lee says, I'm asking. And at 6:03:15 a.m., Lee says, open.
And if we go to the next page.
That's the end of that conversation.
All right. Okay. Let me, brief indulgence. He says open. What was the last message? I apologize. I was following along that you, Jamie sent.
At 6:03:15 a.m., Lee said open.
Okay. So. After receiving that information, you said you previously didn't have the full conversation. But did that amount to, when we look at the timeline of when Jay Lee left his apartment and all that, how did that all connect?
This matches exactly with when Jay Lee was leaving to go to Tim Herrington's apartment.
Did you do any other search warrants?
Yes, ma'am, I did.
And tell me about the ones of interest in the case.
So there are two that are that we found information that we thought was relevant. The first one is the Dirt to Diamonds search warrant, the Dirt to Diamonds podcast at gmail.com. We did a search warrant for the information associated with that Gmail.
And remind me again, what was Dirt to Diamonds?
Dirt to Diamonds was the same podcast that was used to register the Google Voice number that was then used to register the Red I-24 Snapchat account.
And how did you discover it was connected to Tim Herrington?
Both with the recovery phone number and the podcast that he has out for everyone to see.
And that recovery number was his real phone number?
His actual phone number, yes.
So let's start, I guess, with the Dirt to Diamonds. When you applied for that search warrant, did you receive a return?
Yes, I did.
Good, Jerry? Let me know if you're not.
Sergeant Douglas, is this the Google search warrant, or the search warrant you sent for the Dirt to Diamonds to Google?
Yes, ma'am.
Okay. And has it been, does it accurately represent that search warrant?
Yes, it does.
Okay. Tell me again, what date did you draft that and send it off?
This one was signed on August 3rd. We initially sent the first one. We didn't get almost any data back from the original. We didn't write in the search warrant. We didn't explain each individual application that Google has, and so they didn't give us anything back for things like YouTube or Google Search or Google Voice, things of that nature. So we wrote into the search warrant all the applications that Google uses and provides, all the services that they provide, the applications that they run and have, we made sure that those were in the search warrant so we could get information associated with those things from Google. And so we wrote a second one. So the first one we wrote on July 25th. The second one we wrote on August 3rd.
And July 25th, was that be the day that the red eye, like you got Tim Herrington's red eye messages?
July, that would have been the day that we got the return from Snapchat.
So see that whole conversation that we just
Yes.
went over?
Yes.
Okay. This time I would like to mark for identification the Google search warrant to Dirt to Diamonds podcast. Or, yeah.
Okay.
Brief indulgence.
This is the
Oh, okay, here. So. And were you able to get information from that Google search warrant? Did you receive something in return?
Yes, I did.
Sergeant Douglas, is this what you received in return? Could you identify that for us?
Mark for identification, I think.
Let him identify it and then mark it, and we'll go from there, okay?
These are the Google. This is the Google search history associated with Dirt to Diamonds podcast at gmail.com.
Okay. And what was that time frame that you got that for?
We got it up to. It's written in the warrant.
I'm not objecting to it, what Mark, I have an objection to it. She's not trying to introduce it.
I'm going to have him do some further identification for the relevant time frame, mark it for ID, and then I am getting them to
Well, she's
introduce
going to try to introduce it.
You're trying to introduce it after that.
I would need to review my search warrant to know the entire time frame that I have.
Handing the witness what has been previously marked for identification as the S-29.
The time frame was May 28th, 2022 until July 22nd, 2022.
Your Honor, at this time, I would move to have the Google search warrant returned, marked for identification.
Okay, be marked for ID.
Sergeant Douglas, I'm handing you what's been marked for ID as State's Exhibit 30, or State's Exhibit 30, yes. Tell me, when you got that return, did it contain any messages that were relevant?
So these are searches. This is the search history.
I apologize. Thank you for letting me know.
Yes, ma'am. So there is a search.
Answer to yes or no, Your Honor, at this time. Objective, non-responsive answer. The question was, did you?
Go ahead and repeat your question anyway.
Sergeant Douglas, did it contain any messages that were relevant to the disappearance of Jay Lee, Tim Herrington, anything?
Yes, it contained searches that were relevant to the case.
Okay. what was, if you could tell me the time frame of the searches?
On July 8th, 2022 at 5:56 a.m., Tim Herrington Googled how long, or Dirt to Diamonds podcast at gmail.com.
Wait, hold on. It sounded, now that he said they were relevant, I would just move to enter it into evidence at this time, Your Honor.
Object, Your Honor, this time.
Oh, hang on a second. You're asking that S-30 to be introduced into evidence this time?
Yes, Your Honor.
What's your objection?
Your Honor, I'd like to be outside the presence of the jury.
Y'all step that way, be a good time to take a break anyway, okay? So let's all take this short break and come back. All right, let's try to get started back, okay? If you need a minute, let me know, but otherwise, let's.
Thanks.
Judge, as we stated before, as to had our hearing in Ripley as to the Google documents, that would require an expert to come in, either a forensic expert or someone qualified from Google to come in to do those particular documents, Your Honor, as opposed to something that was taken off of a particular cell phone that was extracted onto through a program, then an expert would provide it. Only someone certified either through Google or someone that it can do the forensic download qualified to do that can introduce those documents.
Let me, I know we talked about this last week, and so I'm going to just ask some questions anyway. The document that we're referring to, exhibit number 30, was pursuant to a search warrant where the officer sent Google a search warrant asking for data, asking for what was on Google.
Yes, Your Honor.
And this was received back from Google pursuant to that search warrant.
Yes, Your Honor.
If nobody has objection, I'd like to see what form that is. Is it just written communication? It's
Google searches, Your Honor. Back text messages or something. It's just Google searches, Your Honor.
All right, Mr. Tolan, I'd like to, I'll give you next, tell me why you believe this information is contained. Is this is marked as S30?
That's my copy.
That is, but this is S30 here.
Yeah.
Tell me why you think that is technical data that needs to have an expert to introduce.
Primarily, first of all, I want to go through the steps of how what we were provided in the 90211 authentication certificate that Detective Baker would be the sponsoring witness and the custodian. First of all, obviously this is Ben Douglas, not Ryan Baker. Second of all, is that the data on there is something that was turned on the search warrant. That particular information requires an expert to authenticate that, either authenticate that or testify about the content of it after it's been authenticated. That's consistent with Fleming and consistent with Smith.
All right, but this, as I understand it, this is not something that an officer downloaded. This is something that was received pursuant to a search warrant from Google. Is that correct?
Yes, Your Honor.
I know at some point we talked about this officer or that officer dumping a phone and getting information from, but this is pursuant to from Google.
It is, Your Honor.
Yes, Your Honor. It's a search warrant. It's a search warrant from Google. We mark the search warrant for identification. Google downloads the search history and sends it to us. It doesn't require an expert. Fleming, I read Fleming. The reason that they say it requires an expert is because you're getting into technicalities of triangulating and calculating where someone is. These are just search results, Your Honor. Anyone who could read them.
I'm going to find this does not require a Fleming type expert. I'll give you an opportunity. If there's other grounds for your objections, I'll hear them. But I don't think this reading the words that Google sent to you. It does not require any technical knowledge anyway.
So I'm clear with the court's ruling is it basically that search warrant was issued, material was sent back pursuant to the search warrant, officer received it, came from Google, really doesn't need a certificate of authentication. All he's got to do is be similar to a phone.
I didn't say.
No, what I'm saying is,
That's
I just
two
wanna
different
make
arguments.
sure.
That's just two different arguments anyway.
Right.
At this point, I have said that this is not a Fleming argument, Kite.
I guess what I want to be clear, understand when I cross this witness, I want to make sure that search warrant comes back, as long as the material is something that he gets, anybody can read it, get the material on it, he can interpret it, doesn't require an expert to interpret it, he can testify about that material. Is that right?
That's
Thank you.
That's what I'm finding. Anyway.
Thank you.
All right. Anything else?
Not from the state.
Let's see if the jury's ready, okay? If they're ready, bring them on in.
Not ready for that yet. Thank you, Your Honor.
You want to get it into him?
All right, everybody good? You may resume your.
Sergeant Douglas, could, at this time, Your Honor, I would like to have Exhibit 30 admitted into evidence.
All right, over the objection, counsel, I'm going to admit the Exhibit 30 into evidence.
No, basically, my previously stated.
Previously stated, I think we're okay on the other.
Yes, I do.
Ready, hand it back. Your Honor, may I publish the jury?
Oh, you may.
Okay. Sergeant Douglas, I believe where we left off was you had sent off a search warrant. Explain to us like what we're going to be looking at.
So these are Google search results that came back in the activity of Dirt to Diamonds podcast at gmail.com.
And how did that relate to Tim Herrington?
This is the email address that was on the Red Eye 24 Snapchat account that had his phone number as the recovery phone number and all to identify that it is his account.
Okay. And looking at these search results, could you tell me if there's a relevant one or relevant? Tell me about the relevant ones.
There are a few relevant ones on the sheet that you have.
Tell me where to go.
Let me ask you this. Do y'all want all of those introduced, or do you want just the relevant ones introduced?
Yeah, the entire package. It's just that we're just going to go. He's going to go to specific ones to point out, but the entire package will be there for.
I understand that you may want to introduce the entire package, and I've had an opportunity to look at some of them, but I don't know what else is there for 10 days prior. I don't know what the time frame is. Is it relevant to the time frame in question?
I would like to anything that you feel is relevant. Let's narrow it down to that. Either side feel is relevant. I'd like to narrow it down to that time frame.
At some point in time.
At some point in time. Okay.
Thank you.
Okay. So, explain to us the time frame that these Google searches cover, and these are Google searches, correct?
Yes, ma'am.
Okay. Explain to us the time frame that this covers.
This would cover the entire time frame of the search warrant. So May May 28th to July 22nd of 2022.
No, I think that, I hate to keep jumping up, but surely at some point in time, the council can get together and not take some stuff.
I would like for y'all to try to do that anyway.
Thank you.
Your Honor, we don't plan to go through every message. We're going to go through a few. Sergeant Douglas, take me to the date of Jay Lee's disappearance. Tell me about the relevant searches on July 8th, 2022.
So on July 8th of 2022 at 5:56 a.m., there is a Google search for how long does it take to strangle someone, Gabby Petito.
Okay, so July 8th.
That's on the 7th page of this document.
Okay. So, let me do this. Right here. You see can you see the little arrow?
Yes.
The little red arrow? Okay. Tell me, what time is that?
That is 5:56 a.m. Central.
And what time does it come in? Like what time is was listed on the searches?
It comes in that universal time, that UTC, and it says 10:56:54.
Explain a little bit like what universal UTC time is.
It's just another time zone that's different than ours, as far as I understand.
So when you move it to our time zone, what time was this search made?
The search was made at 5:56 a.m. on that Central Time.
And it said, how long does it take to strangle someone, Gabby Petito? Were you able to learn anything? Do you know who Gabby Petito is?
I'm kind of familiar, but not really.
It's interpreting the content of the message objectively.
Yeah, well, I asked if you knew.
I'm gonna, if he knows who Gabby Petito is, I'm gonna let him ask, but I don't answer, but I don't. Go ahead.
Okay.
I don't have intimate knowledge of any of it.
Okay.
I just know the name from that. There was a big case about it.
Okay. Did you discover anything about this search?
As in what?
As in, how long does it take to strangle someone, Gabby Petito? About what happens when you search? How long does it? Tell me.
Yes. So whenever you search, how long does it take to strangle someone? This is the first thing that pops up in the Google search bar, the autocomplete. So whenever you're typing things into Google and they autocomplete, this is the first one that pops up.
Okay. So as you're typing that, it autocompletes with the name Gabby Petito.
Yes.
Okay. And you said that this was what time when you converted to our time?
5:56 a.m.
And if you could remind me, what time was Jay Lee's account texting open to Tim Herrington's Red Eye account? I believe you said that was the final message. Correct me if I'm wrong.
The time of open was at 6:03:15 a.m.
Okay. And was there any further message between the two accounts after 6:03 a.m.?
No, ma'am.
And this one was at 5:56 a.m., the Google search.
This Google search was at 5:56 a.m. Yes.
Okay. Also on is there any searches that took place after this that were of relevance?
Yes, ma'am.
You can tell me where to go to find those.
The very first page on the back of it.
And
on July 10th, it'll say July 10th at 8:10:44 UTC, which would be 3:10 p.m.
It's, oh. Okay. Am I the arrow pointing to the right?
Yes, ma'am. He searches the Molly Bar apartments. UPD on the 10th released the press notice that Jaylee was missing this same day around this same time. At this time, UPD had not found the vehicle yet. We didn't know where it was at. And once that notice comes out from UPD, he Googles Molly Bar apartments at 3:10 p.m.
Right. And
which happens to be where the car is eventually located.
were you involved in the creation of that press release?
I was. I created the press release and sent it to Lieutenant McGuire to then submit.
And what day and time did you, was it sent out, if you can remember?
I remember it was sent out on July 10th. I know that I sent it to Shayla sometime afternoon.
I'm sorry, I didn't hear that last part.
Sometime afternoon is whenever I sent it to Shayla. I'm not sure when she clicked send on the post to put it up.
And may I have this marked for ID as State's Exhibit
31.
31? I am handing the witness what is now been marked for ID as State's Exhibit 31. Do you recognize that?
Yes, ma'am.
How do you, what do you recognize it as? What is it?
This is the document that was released on July 10th as a press release for the fact that Jaylee had not been seen or heard from since July 8th.
And is that the one that you created?
Yes, ma'am, it is.
And this time I would move to enter the press release into evidence.
Any objections? All right, it'll be admitted. $31. If I'm counting right. Kathy, give me the high sign.
And may I publish to the jury?
You may.
Your Honor, I want to state, I hope the press isn't getting the fact that our plastic's falling down on the window.
Yeah, I know. What?
Maybe the Board of Supervisors need to find out.
Yeah, we'll get some spray paint this afternoon. Y'all, I think everybody but me can see, so we're all right. But it shows me my best light, I think. Want y'all this profile view.
Sergeant Douglas, could you tell me what information did y'all have at the time of the release of this press release about like Jay Lee's disappearance?
We had the video from housing that showed that he had left, when he had left, what he was wearing when he left. We had information from the university that gave information about his car, and we had information about him that showed his date of birth, height, how much he weighed, things of that nature.
And if you could kind of point to sort of the missing person details, what was Jay Lee's height and weight?
He was 5'7", weighed 120 pounds.
I'm going to go back to the searches, that very first page. If you could look for me at the top, the third, or that very first page, the first one from the bottom, or not the first one, but the second one from the bottom.
Yes, ma'am.
Could you please read what that search is?
It says Ole Miss student found in lake.
And what time of day was that search?
4:32 p.m.
On July 10th?
Yes.
And the next one?
The next one is a link to people.com, the Ali Castile murder.
Who is Ali Castile?
Ali Castile is the victim of a murder in Lafayette County.
Was she also an Ole Miss student?
She was.
And the last few, and what time was that one at?
4:32 p.m.
And the last few searches, are they all about that? Like top search, what's that one?
They are. There's a New York Post article about it, and then there's a KTLA article about it.
I'm going to go back to search warrants. I know you got the Google one for Tim Herrington's Google account. Did you get another one?
I did.
And what was that one?
I got one for Meta, so Facebook and Instagram. I sent one to Meta.
No, it's too big. Search warrant. Oh, here it is. Apologize. Here it is. Yeah, we don't have some. is marked for ID as State's Exhibit 32. We now have to identify that. Sergeant Douglas, I have handed you what's previously been marked for identification as State's Exhibit 32. Do you recognize that State's Exhibit 32?
Yes, ma'am, I do.
Okay, and is that the search warrant that you did for Tim Herrington's accounts?
This is the first one. We did a second one. So the first one we sent, and Meta did not want to comply with it, and we sent this one initially on July 22nd. They refused it, so we returned it on August 23rd, and we got a second one on August 5th signed. We also returned that one on August 23rd.
And let me make sure I got there's two of them. No wonder there were two of them. This must be the other one. Is this a search warrant that you did?
Yes.
So the one that I just gave you is the search warrant that...
That is the one that was signed on July 22nd.
And when did you get the next one?
I signed the next one, or I got the next one signed.
Yeah, when you got
on
the
August 5th. We received the data on August 15th.
Okay, so this is the one. State's Exhibit 32 is going to be the first search warrant for ID. And this is going to be the second one. Handing the witness what has been identified now as State's Exhibit 33. Do you recognize that, Sergeant Douglas?
Yes, ma'am, I do.
Okay, and is that second search warrant you were just referring to?
Yes, ma'am, it is.
Okay, and you sent it to Tim Herrington's Instagram and Facebook?
Yes.
Okay, what were those Instagram and Facebooks?
The handle for the Facebook was timmy.harrington.3, and the Instagram was Tim the CEO.
And did you receive a return from that one?
I did.
Okay. And was it a large return?
It was. There was a decent amount of data on the return. We got names, addresses, search history, telephone numbers, IP addresses, things of that nature.
Okay. And did you review that entire return and pull portions to talk about here today?
Yes, we did.
Have this marked for us. Sergeant, I'm handing Sergeant Douglas what has now been marked as State's Exhibit 34 for identification. Do you recognize this, Sergeant Douglas?
Yes, I do.
What is it?
This is a download of search history data from Meta, from Facebook.
And tell me, is this all of it or just a portion of it?
This is all of the search history that we were given.
What was the time frame
The time frame. May 28th through July 22nd.
May 28, 2022 to July 27, 2022?
22nd,
Oh,
2022.
22nd, 2022. Okay. And does that accurately reflect that time frame you requested?
Yes, ma'am.
So that's the full searches for the time frame you requested?
This is the full, whenever we open the document on the computer. When we open the document on the computer, this is the full document.
Okay.
That's was related to search history.
Search history. And at this time, Your Honor, I would like to have State's Exhibit 34 entered into evidence.
Second objection.
All right, previous objection be noted. I'm going to admit it into evidence.
Your Honor, may I publish to the jury?
You may.
Sergeant Douglas, tell me about what page to go to for any searches that piqued your interest.
So on the first page, on 7/10/2022, the UTC time is 10/21/37/36. He searched on Facebook Tony Faris. The UTC time converted to Central would be 4:37 p.m.
Okay. And so what would that time be in Central Time?
4:37 p.m.
And what day was that?
July 10th.
And who was Tony Faris?
Tony Faris was the lawyer that represented the defendant in the Allie Castile murder.
Alex Steele is a student from Ole Miss.
From Ole Miss, the same one in the search history from Google around the same time frame.
Oh, so from when we were looking at the Google from the Allie Castile murder, these are done how close in time?
Within the same minute.
I'm sorry, I couldn't hear you.
Within a minute or within the same time.
Were there any other searches that I should look at here? We should show the jury.
So if you go to the second page, halfway down, on the 11th, you'll see 044635 UTC. He searched on Facebook Oxford, Mississippi Police Department at 11:46 p.m. That's on July 10th.
And what is that time when converted to Pacific our time?
11:46 p.m.
11:46. And now what search do I need to go to next?
If you look one down from that, at 03:0218 at 10:02 p.m. on 7/11/22. It says Ole Miss Police. He searched Ole Miss Police. Directly underneath that one, he also searched Jimmy Lee at 4:01 a.m. on the 12th. If you go further down, or on the next page, you'll see that he searches on Facebook Oxford, Mississippi Police multiple times on the 13th. and on the 14th. And on the 15th.
And tell me, like, what days are these?
These are the days.
What day of a year?
What
month
day?
of the year?
Yes.
I apologize.
Yes.
Month
So this would be July 7/15, so July 15th of 2022.
and he's searching what?
He's repeatedly searching either Jimmy Lee, or he's searching Oxford Police, or Find Jimmy Lee, or Ole Miss Police, keeping up with the investigation, it seems like, by looking over and over again for Jimmy Lee, Oxford Police, Jimmy Lee Ole Miss, Jimmy J. Lee.
And what, do you remember, do you know what day Timothy Herrington ultimately was arrested for the disappearance of Jimmy Lee?
The 22nd.
And does he continue to make searches like that up until he's arrested?
Yes, ma'am.
Brief indulgence. Your Honor, I tender the witness.
All right, everybody good on the list? All right, you may cross-examine.
I'm gonna wait till she go in and get.
I'm sorry.
Take your time.
Stuff.
You need this stuff.
I'll take that. Thank you.
I proceed, Your Honor.
Thanks.
I hope I don't knock some of this stuff off. So,
Oh, I just didn't want to take too much time.
it's okay.
Is this yours?
It's all
This is evidence.
Is that exhibits?
No, I put them all over there.
Thank you. Detective Douglas, I'm Kevin Horan. How you doing?
Good, how about you?
I'm doing pretty well. I want to ask you a couple of things about your episodes involving the search warrants. You remember how many you did?
I don't remember the total number. I think it was somewhere around 25, though.
And your investigation began, I guess, as a missing person, and then y'all kind of transitioned into assisting or OPD?
Yes, sir. So we started it as a welfare concern. The welfare concern, whenever we found the car in Oxford Police Department's jurisdiction, we began helping OPD because we believed that something most likely occurred outside of our jurisdiction because the car was located at Molly Bar Trails.
Okay, I want to hand you the document and tell me if you can identify, have it marked for identification. Have it marked for identification. Alexander's return on JB. I'm going to hand you and see if you can identify your signature. Does that represent the return on the entertainment center out of Mr. Lee's car as a result of
Yes, sir.
the initial investigation?
Yes, sir.
Okay. Have it marked. I mean, you can see it in the evidence at this time.
Any objection? Gonna be D 35, that's return of J. Lee search call. Return.
I just want to be clear, I have no objection to the return, actually, no objection.
Okay, but that's the return of search warrant of J. Lee's car, right?
Second, I'd like to have marked for identification, return on, I believe is you did a search warrant on Mr. Herrington's car as well, correct?
Yes, sir.
And it was the information.
It's called Burla. So the thing is Burla. It's a specific system where a investigator is qualified to go and pull the little black box infotainment system out of your car. That holds information associated with what the vehicle is doing. Vehicles that are newer, it's really good, and vehicles that are older, a lot of times it's not so great.
So you received the Burla report, correct? Does that appear to be that report?
Yes, sir, I did.
Okay. And does that appear to be the Burla?
Yes, sir. This appears to be the Burla report.
Burla, B-E-R-L-A. I'd like to have it introduced at this time. I'd like to have it introduced at this time.
Any objections?
Mark can introduce it at this time.
Any objections?
May we approach?
Okay. Are y'all ready, Mr. Creek? Y'all ready? Okay, good enough.
I'm sorry. That appears to be the Burley report, is that correct?
Yes, sir, it does.
Now, you just testified, I believe, that Burley report and older cars sometimes, they're off a little bit, and in fact, y'all have a report in the file that says it may or may not be all 10 minutes. Is that right?
What I know about
Sheldon McGuire got a report in there that says it may be all.
I'm not sure what Sheldon McGuire wrote in her reports, but I know that whenever I spoke with the people that did this Burla, it was the information that I was given was that it was not good, so much so that they sent it off to Burla themselves. They sent the entire report to Burla to attempt to get them to reconstruct it. And whenever the things that they sent back, the reconstructions that they sent back, they said were not fit. The reconstructed data should only be used as.
Hold on a second. My question was, did you have a report in your file that your officer, your department, Sheldon McGuire, indicated that it was all 10 minutes?
I'm not Sheldon McGuire. I don't know what she wrote in her reports.
You have a report in your file that indicates that, Detective.
Objection, Your Honor. He said he doesn't know what she has in her report. That's the answer. The witnesses answered the question.
Yes or no? That's all I'm asking. You have a report in your file.
What's the objection? I didn't understand it.
Asked and answered.
As to which question? Does he have it or not? Has he answered the question? Does he have it in his file?
He said he doesn't know what she has in her report. That's what he said.
Okay. I'll handle that with Ms. McGuire. All right. Now, I want you to pull to this page right here on 07/08/2022. It'll have the bottom of the page. It's about 2 in, I think.
07/08/22. Is it this one?
That's correct, I believe. And it's 17:30/8/02 time stamped at the bottom. Are you to that page? Next.
This is 17/26/01.
Very bottom of the page. Time step 17:38.
It's not bottom of this page, is it? It's at the bottom of
next page.
It's at the top of the next page, isn't it?
Okay, that's fine. Go to the time stamp that you can find in this report. 07/08/0325/59. You see that entry?
07/38. What?
07/08/22 at 0325/59.
There we go, right there.
All right. Read that entry on that report.
So this entry says door and then driver door was opened at 2022-07/08/032559 opened 07/08/2022-032559 and then local.
What is the entry below that?
The entry below that says door, and then driver door was opened at 2022-07/08/04/1226, then opened, and then 07/08/2022-04/1226, and then local.
What is the next line?
says door, and driver door was opened at 2022 0708 044735, opened 0708 2022 07 or 044735, and then local.
Next entry.
Driver door closed, or driver door was closed at 2022 0708 044744, closed 0708 2022 047 or 044744.
Okay, I want you to go down to read the next entry.
Which one's the next one? 608?
Yes.
Driver door was closed at 2022 0708 06 1108, closed 0708 2022 06 1108, local.
Okay. Now the next entry involves a passenger door was open, correct? Is that right?
Further down it does.
Okay.
Further down it says passenger door was opened at 2022 0708 073440.
And passenger door was closed at what time?
2022 0708 073441.
Okay. So according to this report, on this particular report, talking to Sheldon McGuire about her investigation involving 734-41, passenger door, according to this report, Jay Lee's car opened and closed within a millisecond of each other.
Yeah, but right above it, it says that the driver door opened 3 times without closing on itself.
That's correct. It does say that. It says open, closed, open, closed, correct?
No, it says driver door was opened, driver door was opened, driver door was opened, then driver door was closed. Driver door was open front or
Answer my question.
Okay.
Driver door was open. Driver door was closed. Then up here it says driver door was open, closed, open, closed, then open, closed, open, closed. Right?
Yeah,
It's not open and closing the door, does it?
I mean, with the discrepancies at the start of it, where the door is opened, it could be that it's being opened and closed. It could be that it's not being opened and closed. That's why we didn't use this data.
I understand you didn't use the data, but nobody in the office of UPD or OPD has made any type of report that this discovery that was sent to me was invalid until you testified here today.
Okay.
Can you explain that?
What do you want me to explain?
I want to know why somebody from UPD didn't put in a report that when you got a search warrant back, you got this Burley report, and you sent it to an officer up there in Bartlett, Tennessee, right?
Yes, sir.
He downloaded it, right?
Yes, sir.
He sent it back to you, correct?
He did.
He didn't give you a report that there may be some veracity problems with this particular document. You don't have that report, do you?
Have it in
Yes or no?
We have it in an email, and we were, as was stated earlier, we were assisting OPD with this investigation. Whenever I would write a search warrant and I would get information back, I would take the information. I want to finish my statement. I understand, but I want to finish the statement to explain. I want to answer your question. I'm trying to. So whenever I would get information back, when I would
ask you a question, you can answer yes or no, and then
Explain why there's no report provided in the files to the DA's office or anywhere else that's been given to me in 22,000 documents. Why there's anything in any report that says this stuff isn't accurate. Can you explain that to me? That's my question.
whenever I would get information back, I would give it to Ryan Baker, and he would determine whether that was information that was worth using or not. They would write it in follow-ups. If it was information that was useful, we would write a report about useful information. Information that was useful to our case, to figuring out what had happened.
Okay.
We're trying to figure out what happened to Jay Lee. And so that's this information, because it's not credible. because there's so many discrepancies inside of it, we don't need to use it. So why would we like sit and talk about for an extended period of time why it's not useful?
Well, Detective, I'm a little confused about how it's not useful, because if you look at that early report, and it says the last time that Jay Lee's car door opened and closed was at 7:34, right?
From what you had me read?
Yeah. Jay Lee's car on the same time at 7:34. Even if you take what Sheldon McGuire said, that it's all 10 minutes. I don't know how she came up with that. You got to
Objection, Your Honor. Facts not evidence.
One second.
I'll rephrase my question. Okay. You look at that report. It says that door opened and closed, both passenger and driver side door opened and closed within 1/10 of a second of each other. When's the next entry that anything happened on that car?
On the 8th, it says driver door was opened at 7:38:07.
What time?
Driver door was closed, so it says passenger was closed, and it says passenger door was closed, driver door was closed, driver door was closed, driver door was closed, driver door was closed 4 times in a row between on the 8th at 07:38:07, then on the 9th at 4:47, then on the 9th at 6:01, then on the 9th at 7:18, then on the 9th at 7:18. So that one says open. But right after the passenger door was closed, the next 4 on this document say driver door was closed, driver door was closed, driver door was closed. So it's saying that the next, and then the 4th one, the driver door was closed. So the next 4 times that on this document, it's continually saying the driver door was closed even though it wasn't open. The driver door was closed even though it hadn't been opened. The driver was closed even though it hadn't been opened.
The next entry, my question was, when was the next entry after the 7:34 was what time?
Which 7:34? So passenger door was opened or closed?
All right, it was 7:38:08, correct?
The driver door was opened or closed. Driver door was closed again at 7:08:22 at 7:38:07.
I'm just trying to get you the next entry on this Burley report after the 7:34:41 was
7:38:07.
Okay.
Yes.
Now it says driver door closed at that time, right?
Yes.
All right.
Yes.
It
says close.
It says driver door closed on the next entry on 079 at 22 at what time?
At 04:47:33.
Thank you. And what time would that be the next day?
This just says 04:47:33. It doesn't have like any sort of time standard on it.
Right, we'll get back to it. Detective, I want to ask you about a couple other search warrants you did. Did you do a search warrant on the automobile of Mr. Herrington?
No, I did not.
You did not do that?
No.
Did you assist in that search warrant?
No, I did not.
So, when did your investigation conclude?
When did my investigation conclude?
UPD's investigation conclude, and y'all became...
we began helping OPD on the 10th whenever the vehicle was recovered. But our investigation hadn't concluded. We continued to assist.
That's a bad term. I guess my question is, when did y'all become associated with, basically, I know you didn't turn it over to Oxford PD, but y'all working on it together. What date was that?
That would have been the 10th, whenever the vehicle was found that night.
And would it be a fair statement to say when Jay Lee disappeared initially, and even up until the time that Mr. Herrington was arrested. The activity that you talked about today, as far as Mr. Herrington searching certain things, that was not unique to him. He searched a lot of other people's messages and things like that on Facebook, students and other people, members of my family. You would find the same and similar type search engines, would you not? Search conduct.
Objection to speculation.
I sustain the objection. Rephrase your question anyway.
Did y'all search anybody else's Facebook pages before? Did you do any searches of any Facebook pages besides Mr. Herrington?
No.
So you don't know whether or not Jose Reyes or any of the other people that may have known Jay Lee or been associated with Jay Lee had similar searches on their Facebook and inquisitive comments and things like that, or searches. You can't say that they didn't do the same, right?
No, I can't say that they didn't do the same.
Okay. Now, you identified tell me how far back the Snapchat search went?
I'd have to have the Snapchat search warrant. It'll have the dates on it.
You only did July the 8th?
I'd have to have the Snapchat search warrant. I need to have the dates that are on that warrant.
When you searched Jay Lee's Snapchat, you found information on there, I assume, based on what I've been provided, that there was a lot of conversations between Jay Lee and other people that he had apparently had sexual relationships with, contact with, things of that nature, right?
I know he was speaking to a lot of people. I don't remember the nature of every single message, so I'm not sure.
Appeared by the nature of those conversations, the possibility or probability existed that he was in a relationship with a number of different people.
Objection to speculation.
Part of his investigation.
I'm going to ask him what he remembers from that Snapchat.
I just remember reviewing it. I don't remember finding anything inside of his Snapchat that we marked down.
Thought was remarkable at all?
Yeah.
Did you find any conversations in those chats, any messages, or anything similar to any of the type of conversations that you've identified in the Snapchat that published to the jury?
Which, you mean the red eye Snapchat, the red eye _24? I don't remember whether I did or not.
All right. Did you look for any other conversations pertaining to things that Jay Lee may have said similar to the things that he said to Mr. Herrington on the date, July the 8th, that you interviewed through your search here today?
I know on...
Objection on relevance.
I think it'd be relevant.
He hasn't specified, there's different comments, I'm not sure what comment he's referring to. He said similar to the thing.
I'm going to get to it. I mean, but still, I'm just asking you to find similar comments and conversations between Jay Lee and other individuals using the same terminology, things of that nature, with other individuals.
I'm not sure. I don't remember.
Certainly. Y'all's back anyway, and I appreciate y'all remember the court's instructions.
This is my introduction.
I'm gonna.
Brief indulgence, Your Honor.
Mr. Horan, I'm not gonna judge the whole book by its cover, if that means anything. If y'all get me down to particular instances, I'll make a one by one decision on them, okay?
Yes, Your Honor. I think what I can do is, Your Honor, without it, even from being confusing, I think I just showed the highlighted portions of what I've got of all these text messages, chats.
Are these out of something that's already been introduced into evidence?
It is.
Which exhibit are we talking about?
Talking about the
Snapchat or?
chat.
Your Honor, what we introduced was the search warrant and then of the Snapchat, and then we introduced a portion of the chat from that search warrant. That's what's been introduced. What Mr. Creekmore was referring to was the issue of third-party guilt. This is a separate issue that as to hearsay. The case law says that when criminal defendants, it says that.
Let's don't run that rabbit right yet. Now I want to find out what he's offering in the testimony, and then I'll have use for more information. But
okay,
I want to see what he's offering first, and then that will.
Your Honor, I can state into the record. I think it'd be easier to do that, and I'm not going to identify the recipient of the information because I don't think it's relevant.
What was said
By Jay Lee.
By Jay Lee. Or you can tell me what your conversation was. Just don't give me any names at this time, anyway.
Okay. An individual texts Sucker for Jay and says, "Whoa, physical assault already?" Sucker for Jay. Response, "I want to punch you." Your Honor, it does have other conversations placed in context as far as relationship, and I don't think the content.
Is that there's a lot of people in the world I want to punch, but not in sexual nature. If that makes any sense anyway, I don't know if there's enough information there to decide what the nature of it is.
Again, that's the basis of it. There's additional language in there that indicates that But they're talking about a part of your body. It's all kind of sexual.
Just show it to me anyway.
That particular page down to the blue part. Just read that whole page.
Plot or into the blue part.
Above the blue part.
And I'm not clear, is this already, what are you referring to? Is this marked for ID?
It says chat, so it's got the sucker for whatever medium that the handle, if you see B, was sucker for J. Lee is, whichever one that was.
This has already been received into evidence?
I don't know how much of it y'all put, I don't know how much of the document y'all put into evidence.
No, I'm asking about what you're referring to.
I don't know. I
Don't know
don't
if you're
know how
referring
much
to-
y'all put in and whether this has been introduced or not.
If he could establish what he's,
If it's in evidence, it's in evidence.
In evidence.
If it's not in
That's what
evidence,
I want to
we
know.
got
That's
something
the
to argue
question.
about.
This is in evidence.
All
Not
that.
evidence.
Let me see.
No. It's ID'd at this time.
It's not in evidence. Your Honor, we introduced the Snapchat, I apologize, we introduced the Snapchat search warrant, and then we introduced a portion of the chats. This portion is not in evidence. That's what we're trying to say.
All right.
Now, what I'm saying is, these portions are ID. He's identified these in his ID part when he testified that these have been identified as being all the proper authenticated documents of the Snapchat that he's subpoenaed for the relevant time frame, from May all the way up until the day of the offense.
I'm on.
I have more, yeah.
All right. I'm gonna read this.
Wait, give me the other.
And make sure I'm on the right page. The left hand is the fender. Okay.
That's Google. Here you go.
27.
This is 27, 28. Those are the messages.
This is 28. 28 is in.
Yes.
Can we put a clip on this? Where's 27?
Your Honor, if those are from Jay Lee's account, that's not from the Snapchat return. Jay Lee's, they did the Snapchat return on Red Eye 24. The messages that we introduced are from the Snapchat return of Red Eye 24. We never actually introduced the evidence of the Jay Lee's account because he talked about his investigation and getting the download from it, but we never introduced the Snapchat of Jay Lee's account. So those haven't been authenticated yet.
27 is the search for Snapchat for
Yeah.
and then 26 was the subpoena for
Well, we're talking about This information above this line here?
That's the relevant part. That just leads up to that right
And when is this?
there. Back in June.
I'm on, as to the two locations that, that are mentioned there, I don't think it amounts to nothing.
Huh?
I don't think it means much one way. or the
Well,
other.
I got somebody just to show.
But I won't, as to those, I think, you can tell me, but
Here's the other one, yeah, just more particular.
I'm gonna take a real quick break. I'll be right back, and I won't get back on the record anyway.
Judge, I may have to leave it cleared up.
Okay.
I'm going to introduce return on the Snapchat record. Have him identify these records consistent with what he had in his return.
Get me clarified before the jury gets back as to what documents we're dealing with, okay?
All right, we good.
All right, then I'll make some rules.
This one right here. I'm on, again, Your Honor,
that right?
That's correct, Your
All
Honor.
right, is there any objections, once he's laid a foundation as to what this is to those statements highlighted in blue?
Yeah, multi-fold. My objection first is, Your Honor, one of the statements I looked at, it's when you read it in context, it's clearly flirtation. Obviously, we don't want to put it into context. It's also, that one was from like June of 23, but if you black out, it takes off the context. But I would also say, Your Honor, that we believe it's hearsay because the victims put forth as the victim statement. The reason that when we introduced the statement of Timothy Herrington is because that was the defendant's statement of a party opponent, but they have not introduced the extra exception for why that can be, it's not hearsay. But, and then Mr. Creekmore had something regarding third-party guilt.
I don't see anything, I would say this, I don't see anything in the statements that would indicate that they're trying to establish a different suspect. Is that,
No, sir.
I don't see anything in the statements that, I don't think that's really relevant anyway.
If that's the case, then it is not relevant.
Well,
It's
I don't know what
relevant.
the
He made similar
purpose is.
comments, just like they're just introducing the evidence to other people. I'm not going to put the recipient's name in it.
If it's saying, basically, y'all have introduced evidence saying, are you gonna whoop me? Or am I coming over there for ass whooping or something like that? I think the terminology was anyway. If he said something similar to other people, I'm going to I just don't see that.
Your Honor, I believe we have a case that's fairly similar.
What?
We have a case that's where we are right now. It's Garlington Big Steak, 349 Southern 3rd, 782. And in that case, they were trying to introduce, the defense was trying to introduce proof that somebody else could have done it based on a statement made by someone that was not present to testify. And that's what we have here. We have statements that are contained in the messages, but that person is not here to testify. We're not here to be able to, they're not here for us to be able to cross-examine.
I would like to know what your line of questioning is. Are you trying to develop another suspect or not? And I don't read them like that, but tell me what you're trying to do and then what your question would be.
Their whole basis, the whole body of their case is that I think we're going to hear that our client are insinuating from these messages that our client solicited him to come over there and do certain things. Unfortunately, when you hear the rest of the evidence, there's some other, you let it in, other documentation is going to indicate that the alleged victim in this case started the conversation. In what they produced right now, there's clearly a statement in there that says, you better not try to do anything, not going to turn out good for you. Well,
first of all, I hate to interrupt his argument, but he started out wrong. The conversation between Jay Lee.
Let me finish. Could I finish?
Hang on. Let me see. Do what now?
The conversation between Tim Herrington and Jay Lee was begun by Tim Herrington. That was a mistake of the law. I mean, of the facts.
Yeah.
Just give me to what was said. What was said that you find that you have a right to introduce this?
In the conversation, there's two things that basically the theme that they're trying to lay out is that our client solicited him to come back over there. It's in their particular evidence that they've introduced at this time. Included in that is a statement wherein Jay Lee, according to their evidence, made a comment to our client about it's not going to turn out well for you if it goes bad. That's in not only that, but the discovery material that's been provided on other media, which they're going to assume they're going to get in at some point in time. In this particular evidence that they provided in discovery, he's identified as that he did 2 subpoenas and one of them was Snapchats of Sucker for Jay says, I got a pitch, and you better not be trying to pull a fast one on me about what I'm saying. He's talking about conversations about hooking up and getting together. That's consistent with what they've already introduced to negate.
I don't see that. I don't see that that's. I'm having a hard time with that. Those particular words, fine and revel. You don't pull a fast one on me. I don't find it to be relevant to the information that the state has put forward. There's some more documents there that you wished I may find a different ruling on.
Your Honor, if I could, basically, if I can get the exhibit.
While he's doing that, Your Honor, I just want to clarify, when what we introduced, it starts off with, who is this? Jay did not start that conversation. Someone said, who is this?
I've ruled for you. I'd hush if I was you.
I would say, in paragraph 84 of the Garland case, it said that the defense presented evidence at all that person that they were trying to bring in a statement against had been implicated in any way with respect to the crime. And I think that's what we have here. There's no implication that this person, whoever they are, it's not in court today, has any implication in what's going on here today. I don't necessarily think that that's been offered for that purpose, but at the same time, I don't think the statement that you just made is anyhow relevant in this particular case. There may be some of those highlighted that you have that are, but I don't think that one is anyway.
Your Honor, again, conversation, I just want to say it one more time so the court's clear. Conversation initiated by Sucker for Jay. We found out that's Jay Lee. Who the TF is this? Initiated by Mr. Lee. In the body of what they introduced in the evidence is clearly a quote, a statement from Jay Lee. If you try something fast, it won't end up good for you. That's a statement from Jay Lee to my client. It's introduced in the evidence at this time. Similar statement made by Jay Lee that I've just spoken into the record to another individual during the course of a hookup, indicating to him, we're going to get together. I'm letting you know something goes. I'm going to make sure.
Let back up through that. I think let me read this line before that anyway.
You know what I was going.
I took it to be if you don't show up.
No, it's not about you don't show up.
One of them was. Let me look at it again anyway.
What do you want to look at, Judge?
What statement you just read?
Okay.
I want to look at the
contact. The one that was. Is that the one that the exhibit?
28.
Yeah.
28.
That's the one.
At the second page, Your Honor.
I'm not talking about Jay Lee's statement. I'm talking about the statement, the highlighted in blue statement, trying to question the witness.
Right here. I don't know how similar those two thought processes to each other and having the exact same comment.
One of them appears to be, this one appears to be asking for a picture. I got a picture and better not be trying to pull a fast one. I'm for about what I'm saying. Laugh out loud anyway. Yeah, I can't see it. I don't think that the context of asking for a picture is relevant to this particular case. You have, and I'm finding it's not. There was other documents there that you were attempting to, and as I said, I'll judge them on a case individual basis.
Your Honor, second one is the comment that during the course of a conversation with the individual questions Mr. Sucker 4J, which is J. Lee, whoa, physical assault already? And he says, I want to punch you. Then they get down to having some conversations about fighting.
Let me see.
Later on, way down.
All right, I won't go up.
Read from the bottom up.
Sucker for J. Lee asked the person, send pictures of you. The other person replies, when I lift weights, I feel like the Hulk. Sucker, J. Lee says, you act like yours any bigger. The other person says, I'm positive I've seen your arms. J. Lee says, you sure? The other person says, no, because you can't hurt me. J. Lee says, is that bad? And the other person says, whoa, physical assault already? J. Lee says, I want to punch you. The other person says, that's crazy. The other person says, on down here, J. Lee says, you're just mean to me. And I think that could be a frown in
I think it's an emoji. Yes.
Frown.
You're getting better, Judge.
All right. The other person says, how? J. Lee says, you're so mean. The other person says, I think, yeah. The J. Lee says, F you. Other person says, I don't fight women. J. Lee says, you want to fight.
I think it actually goes the other way.
Do what?
I think it actually goes the other way because he says I don't fight women, and then J. Lee says F you.
J. Lee says, you want to fight.
I think it's actually from the timestamps, John, I believe it reads from the bottom up. So it actually, he says, I don't fight women, and I believe J. Lee's response is F you. So it's like the conversation goes from the bottom up.
I don't, okay, I see that. You want to fight? I don't fight women. F you. You're so mean. You're mean to me. I think it's marginal value, but I'm gonna let you talk about that. But I'm gonna get the state talk about all of it.
You already denied the one I really wanted.
You what?
You already denied the one I really wanted.
Okay. That one does not appear to be asking for pictures, is what it seems to be in context to, and I find that's not relevant in this case. But on the one that. The one he just said there, if he introduces part of it, I'll let you cover the whole spectrum anyway, if you like.
Yeah, for context, he had a lot of different pages. Is
that information that I just read anyway?
Mark that for ID right now so that we can.
I haven't introduced. I'm just gonna move on to something else.
Okay. He's gonna move on to something else, he said. All right, show the jury in. I will, Mr. Hogan, I want to make sure you know that the one that happened on the day of the July the 8th, you can introduce that if you want to.
Your Honor, probably before I rest,
Two out of three ain't bad.
I'll have them marked, and
I'll let you make, mark them, and identify them. You think you can identify them, with the jury sitting here adequately? Ms. Tolan, you think you'll be able to identify them adequately for the record with the jury sitting here?
I don't have a problem with that.
I think you can, okay. All right. You want to do that now?
I do. I get that out of the way, Your Honor.
Let the respect the one that there's only one that I denied you the right to qualify, to object on, okay?
Right, that's right. Your Honor, for purposes of the record, I think what I'll do is mark those that, before I obviously won't introduce him, but since we've had discussions about the highlighted portions, I'll mark them as highlighted for purposes of the record, so it'll be clear on the record.
Okay.
Fair enough?
Okay.
I'd like to have, these other ones marked by identification, please. There's 4 of them, separate.
That's just one composite exhibit, is that correct? 137? You got 30?
Do it separate. You
separate
ruled on them
exhibits.
separate.
Okay, all right. I would like for you to state for the record the one that I denied you, whichever one that was.
Detective, I want to hand you.
Mr. Horan, before you get into that, I'd like the record correct. I don't know which number got assigned to each record. Courts, I think, only denied the admissibility or the question of one. Please identify which one that was. Okay. Okay. Before we're through, anyway, so the record be complete.
At the appropriate time to be introduced once it's.
What number?
41.
Is that a new one that we hadn't talked about, or did I get lost, or did I lose it?
Told me you wanted me to let you know which one was the exhibit that you said was admissible at this time.
All right, I had 30. How many did you had 4 documents? What was
37 is the return.
Okay, 37 was return. Okay, that got me off of. I didn't get that.
Your Honor, can we approach just briefly?
Okay, let's make it real brief.
Detective, I want to hand you what's been marked and for identification. Can you tell me whether or not that appears to be the return on the Snapchat conversation, some of which we talked about earlier today, for the Sucker for J. Lee account?
This is the return for the Snapchat account associated with I am J. Lee and Sucker for J. Lee.
I move for introduction of that.
Same objections. My objection previously was to hearsay, and he hasn't articulated why the statement of J. Lee is not hearsay.
And this is just the return.
Right.
I'm going to omit the return into evidence.
Okay. And the other's been marked. You indicated during your direct examination that you did a search warrant for the entertainment of Mr. Herrington's car. Is that correct?
Yes, sir.
You did not get a return?
I don't believe so. The data was unusable.
You didn't get anything back on the entertainment center indicating that it was sent to you as a result of your search warrant?
I don't understand the question.
I hand you what's been marked, or needs to be marked for identification as I was sent a return. Had it. Go through the car first. Did you were you involved in taking actual possession of Mr. Herrington's car?
No, sir.
Did you, when you went and got the search warrant for the entertainment center or information center in that car, how did that transpire?
I don't understand what you're asking. Are you asking about how we got the search warrant?
The car, how did it come to be that you got custody of it, did the search warrant on the car?
Oxford Police Department had possession of the car.
Okay. But you did the search warrant, correct?
I did the search warrant for the entertainment system, not the vehicle.
Okay. And is your understanding that you did not get
Clarify return. What do you mean by return?
anything when you issued search warrant, got a return, did anything come back from the manufacturer of that vehicle for you?
So Lynn Starkey in DeSoto County is the one who dumped it for us, and the data was just unusable.
respond to about what he knows and doesn't know. If he doesn't, I don't know enough to rule on your objection anyway. Let's see how far we get.
You just testified that you got DeSoto County to do a dump on it, correct?
Yes, sir.
And did they return that dump to you?
Yes, sir.
Okay. And it provided no evidentiary value whatsoever. Fair statement?
Yes, sir.
And you remember when you got that?
I do not.
Okay. I'd like to have this marked. I'm going to do it as a composite. I'm going to make sure it doesn't have any biographical information. For the record, I'm going to just do 2 pages of it. There is some information on some of the other pages. So, composite is a for identification offered in the evidence.
Your Honor, objection to hearsay.
I don't know what we're looking at there, so I can't tell you if it's hearsay or not anyway. Let the witness identify it if he can.
I'll do it that way.
And then I'll make a ruling, but I don't know what he's talking about.
Have it marked for identification. 2 pages. Detective, I'm going to hand you what's been marked for identification. It's the exhibit number 42. Can you identify that as being, can you identify that as all both pages?
I personally can't say that it's all the report. I can identify that there are 2 pages here, and it says end of report on the bottom of the 2nd page. But I didn't write this.
I'm not saying, can you identify that particular item? Is that the return of the search warrant from the information center that you got? Send it up there.
This is Lynn Starkey's report on when he downloaded the data from the Ford's sync module.
Read. Can you identify it?
I can identify the car as Tim Herrington.
Okay. Right. If you look at the bottom of the report.
Your Honor, the witness has
There appears to be a picture of the car. Yes, can you identify the car?
I did. I thought I did.
Can you identify the car?
Oh,
Let's
can you identify that item, that particular document? Can you identify the car?
I can identify the car in the pictures.
Okay.
I didn't write the report, so I don't know what's in it. And this isn't what we received as a return as a result of that search warrant.
All right. That's in the file that they provided to me. You identify the car.
The witness has answered the question. This is not what they received as a return.
The last question I heard asked was, can you identify that car?
Can you identify the car?
Yes, this is Timothy.
Right. Look at the 2nd page. Look at it really good. It's not a trick question. Can you read that page? Can you identify that particular item? Something that y'all received.
Personally, I don't know what this is in the picture. I can't explain. It just looks like a hard piece of technology to me. But Lynn writes what it is in the picture or in the report.
I'll introduce.
If he doesn't know what it is,
Identify the car. I'll withdraw the 2nd page.
I know the vehicle is Tim Harrington's vehicle. I saw that.
I move for introduction of the vehicle.
Objection, Your Honor, to hearsay and to relevance. This is hearsay because although it was received via a search warrant, there's no certificate of authenticity. He's saying it's a vehicle. If you want pictures of the vehicle, redact all the language off of it. Your Honor, it's hearsay.
I don't know what's contained on the thing. Right now, all we know is that the witness has identified that vehicle. Anything else would come off anyway.
Can you identify the vehicle in the photograph?
Yes.
Okay. Move for introduction of the photograph.
Let me see what it's on there besides the vehicle anyway. And,
Okay, detective.
Yes, ma'am.
Your Honor, it's admissible.
I don't think there's anything that hadn't been, they did a dump on it anyway.
Your Honor, can I just, I don't want to belabor the point. This is a report, an agency report.
Objection, Your Honor.
8036 allows for introduction.
Hang on 1 second. You've asked for this to be introduced in the evidence.
That's right.
I'm going to let this page be introduced into evidence.
Thank you.
All right. We'll fight the next time when we get there. But
Yes.
I'm going to let that be introduced into evidence. And I'm sure that's not going to be the last fight. That particular page comes into evidence. The second page doesn't come into evidence. Okay? The witness says he don't know what that is. All right, go ahead.
You indicated that this second page, the first page and the second page was the report of Detective Stark, correct?
Yes.
That is a regularly kept record, business, public record, a report that y'all keep within y'all's agency, correct? That he kept.
It's not my agency.
I'm laying the foundation for 803 introduction, Your Honor.
I'm going to let you ask the question.
Just trying to speed up the process. This is a report that Detective Starkey worked for y'all at this time. He did as a part that worked. It's a report for not for y'all, but for Oxford Police Department.
He didn't work for Oxford Police Department. He worked for DeSoto Police Department, I think.
Sent this report, placed in your file, is what I meant to say. This report came to y'all.
Yes.
Became part of your investigative file.
Okay. Yes.
Right? As part of this report, became a part and parcel of your entire investigative file in this particular case, right?
Yes.
All right. Move for introduction this time.
I hear your objection.
Objection, Your Honor. He skipped over the part where it's a regularly conducted business activity. It's not a regularly conducted business activity.
I'm going to deny the introduction as a regular kept business record. If every police report would be introduced into evidence, if that was the case, and I don't think we tried. I'll let you talk to the appropriate witness about it. But even if the detective whose report was there was sitting here, I would not allow the introduction of their report. I would allow you to cross-examine them on that report, but I would not allow the introduction of it.
Your Honor, 8036 clearly says once it becomes part of confrontation clause doesn't apply to a defendant. Only applies to the state.
I'm not worried. I think it's hearsay,
I'll move on.
If every police report, because it was a police report, got introduced into evidence, we'd just let the witnesses read the police reports. Go ahead.
Thank you. All right, Detective, when you got engaged in this particular investigation, and you subpoenaed the Red Eye account, can you tell me when that Red Eye account was opened? Pursuant to what's been introduced in the evidence. What did your report tell me?
I would need to look at the subpoena or the return that we were given.
Is it a fair statement it was not opened up on July the 8th or July the 7th, 2022?
That the report itself was not open?
The Red Eye account was not open on that particular date.
What do you mean created? So it was created previously, but it
was created previously.
Okay. Yeah, created. Okay.
Fair statement, your recollection, that was sometime months prior to that the Red Eye account was opened up. Is that right?
Yes, it was created and deactivated and then reactivated.
Okay. Activated, reactivated.
Yeah, deactivated, reactivated, deactivated again, reactivated again. I don't remember how many times, but I know that it was activated and deactivated and then reactivated.
Done a lot of these types of subpoenas, correct?
I did a bunch of them with, I personally didn't send this subpoena. This was Detective Baker's subpoena that I was there whenever it came back. So I have not done subpoenas like this. I write search warrants. I've never issued subpoenas like this.
But my question is, you've been involved in investigations where you've seen similar activities where accounts are activated, reactivated, things like that on these Snapchats, people letting them go on for a while, then they open them back up. And they have 5 or 6 of them, right? You've seen that before, haven't you?
Not in my investigations. Most of the time people have a single account and they use that single account. And if they have an alternate, they're not deactivating it and reactivating it and deactivating it and reactivating it. They're usually just, they have the single and then the alternate.
As far as your previous testimony pertaining to Jay Lee, opening up, you testified about having blocked message.
It blocked an account with the username Tim Herrington.
Did he block anybody previously that night other than this account?
I am not certain.
Well, you indicated on direct examination that you looked at his block history.
Yes, there were a lot of people on his blocked history. It wasn't just Tim Herrington.
And it's fair to say when you're looking at that block history, it's kind of like old school. You're hanging up on somebody, you don't want to talk to them anymore, you unblock them sometimes. You saw that his block history, he's blocking and unblocking people throughout the entire history of that account, right?
I don't know if we ever could see whenever he would unblock a person. I think we just saw the blocked accounts.
His blocked accounts, but you can't see when he unblocks.
I don't believe I ever saw like a page where it said blocked and then unblocked and then blocked and then unblocked. The page that we were talking about was, it just said blocked.
Okay. But you were looking at his block history, fair statement?
Yes.
And that was not unique to just Mr. Harrington's account, right? There were other accounts, like you said, he was blocked.
Yes, there was more than one account that he had blocked.
Now, do you recall the first time that you went out to Molly Bar Apartments and engaged yourself in knocking on any doors?
I don't remember what day it was, no sir.
Did you look at your report? You got your report with you?
I didn't write a report about that, I don't believe.
Be consistent with somewhere around early on in the investigation, right?
It would have been early on in the investigation. It would have been around the 10th or the 11th whenever we found the car.
And did you make any report or anything like that? Or have you seen anything in your report that indicate which doors that officers went to and knocked to see who may have been home, who was residents at that, or did you compile any summary pertaining to that?
I didn't create a summary pertaining to that. No, sir.
Did not? You know what officer may have done that?
I know a lot of officers that did that.
You don't know which one did it?
I'm not sure which one.
Y'all may be need prepared.
I think that's all I have.
Okay, well, I was just finna say we may be running late tonight, but we may not be anyway. Redirect.
Oh, sorry. Sergeant Douglas, I want to give you an opportunity to explain. We'll go back to the Burla. They were talking about the Burla. Explain what the Burla download from Jay Lee's vehicle. Give you a full opportunity to explain what you were trying to say about why you all didn't rely upon it.
So whenever we got the return from Jay Lee's Burla, we didn't believe that the information was credible because there were multiple times where it would say like, driver door opened, driver door opened, driver door opened, driver door opened, but it was never closed. And so the driver door can't be opened 16 times and never close. Because of things like that, and because we had video footage that we knew that this is when the car was still, or we knew that this was when the car was driving, and it would say that it had been put into drive or put into neutral, things like that, where there were times that didn't match up with information that we knew, and there was information inside of it that was repeating that just, if you look at it, it just doesn't make sense on its own. And so we didn't believe that the information inside of the Burler reports for Jay Lee's car were credible.
And did the Burler report even have a time stamp or, I guess, time zone? Like what?
I remember that the digital copy did, the one that you receive that way. This one doesn't say, but I know that both of them had converted it at some point, but I'm not sure what they converted it from or what they used to convert it.
You were asked about the searches on the Facebook, Timothy Herrington searches for Jay Lee. Facebook, when did the BOLO go out? Which I believe is Be on the Lookout. When did that first go out, if you remember?
I don't know about the BOLO. I know that the public service, like the public announcement on Facebook and all that kind of stuff, that went out on July 10th.
And after that came out, did several people reach out to you, to UPD and to OPD regarding to help with this investigation?
Yes.
Okay.
Yes.
Was Khalid Fears one of those people?
Yes.
Okay. And why did he reach out?
He had spoken to Jay Lee the night that he went missing.
And did Timothy Herrington reach out?
He did not.
One final question. When was the Red Eye 24 account closed?
July 8th. On July 8th is whenever the Red Eye 24 account was deactivated.
So it was deactivated on July 8th?
Yes.
No further questions, John.
All right, that came to a head there all at once anyway. May this witness be finally excused, or would you ask him to remain on the subpoena?
He should remain under subpoena, Your Honor.
Officer, you can, Douglas, you can be excused today. You can't be in the courtroom, and you don't discuss your testimony with anyone else. You're subject to being recalled at a later time, so don't discuss your testimony with anyone, okay? But you're free to go. You go where you want, jump in this courtroom. Make sure that both parties can get in touch with you if they need you back, okay?
Thank you very much.
Thanks for being here. All right, it's 4:44, but if you got a witness, we can get some good out of it. Y'all not eating supper till 7 o'clock tonight anyway, and so we might as well be doing something anyway. If you got a witness that's available, I want to get started on them. If you don't, we'll do something different. Have you got a witness we can get started on with today? Y'all come talk to me about our progress so far. I know what I think about our progress so far, but y'all may have a different assessment of it than I do. pack up and go home, try to get ready to go home. You know anything else we're gonna need for the record today? If not, I'm gonna let Honey Lamb go home.
I believe we can probably say we're done with the record.
I do want to put something on.
Okay.
Okay, go ahead.
Stand corrected.
Mr.
Flink.
Whoever they are.
Well, Your Honor, the one that we had for Renaissance Bank, I believe
What
was
now? From where?
Renaissance Bank.
Renaissance Bank, okay.
It's a business record. No, that's not it. That is a business record.
What do they want to do?
I'm trying to figure it out.
No, I'm waiting for him to finish.